Construction for mine.
Where's the witness? If you'll come and resume the stand, please. It's cross-examination. You may bring the jury. Thank you. Good morning. Welcome, ladies and gentlemen. Day 14. Cross-examination continues. You may proceed.
Good morning, sir.
Good morning.
And this will be very brief, I believe, but just very briefly, yesterday we covered that it was difficult to download the information from the vehicle because it was encrypted by the manufacturer, correct?
Yes, the encryption was done by the manufacturer.
And you essentially had to reverse engineer the device using a test vehicle.
That's correct.
And looks like you got a lot of good data out of it, but there's some of it that isn't quite clear. Like we said, that we didn't exactly know what necessarily would trigger something like a system startup.
Correct.
But some of the other ones would be pretty obvious, like engine on obviously means somebody cranked the car. Right?
Yeah, the engine was turned
Right.
on at that point.
Okay. I'm not going to go through that spreadsheet again. I just wanted to clarify that. And how long did this process take you, this reverse engineering process?
Our whole analysis took just about 1 year.
Wow. It's a long time to.
It's a hard effort.
Will you be able to reuse this work on other 2021 Chevy Suburbans?
Some of the tools we developed will be reusable.
And I asked before, and I guess no one reached out to the manufacturer for assistance in this process?
Our group did not.
Okay. Do you know why? I mean, I think yesterday you said in the past there wasn't, they weren't very helpful, but it seems like the worst they could do is say no. Do you know why it was decided to not reach out?
For our unit, I believe that our attempt is to get the data ourselves without outside assistance. In many cases, we end up finding data that even the manufacturer doesn't know is there.
Okay. Now I want to turn to what I think a technical issue was resolved, and I'm going to show you a printout that has been marked as Defendant's Exhibit 90, and I believe you've had a chance to review this.
Yes, sir. I've reviewed this material.
And you recognize it.
Yes, this is from our results.
And what is this?
This is a list of events that were recorded from the vehicle. There was a category we called events that just listed times that something interacted or something occurred with the vehicle.
And on this printout, the only event, I guess, listed here are iPhones or something called Richard's iPhone earlier on connecting to the vehicle. Is that correct?
I see from the first page here, yeah, there's one that's labeled iPhone with a Bluetooth MAC address, and it's a device connection timestamp.
You've seen this before in your review, and you can look at it now. Do you see is this pretty much all device connections, phones connecting to the Bluetooth in the car?
Yes, I see other Bluetooth devices connecting as well.
And is it, just to be clear on this, the only phone connecting in the month of June, at least, is one named iPhone that has a phone number ending in 1227. Is that correct?
The phone number itself is not listed on this page. It is the Bluetooth MAC address that is identified by.
Is the under connected devices, right above the word events where it says iPhone and there's a MAC address, is the IMSI number that's listed there 803-942-1227? Is that the phone number?
That's for the iPhone, correct?
Okay. And that's the phone that was connecting in June.
That appears to be the only one that connected in June.
Yes. Is this something that you also had to reverse engineer out of the vehicle?
Yes, all of the data we found was unknown prior to taking a look at the test vehicle.
And the event that we're looking at here, device connection, that is the phone connecting to the Bluetooth in the vehicle so that, you know, you could use it for whatever goes over the Bluetooth connection, whether it's phone calls or apps or whatever, depending on.
Yeah, and it indicates a connection event from the Bluetooth to the vehicle's infotainment system.
And up here in connected devices, does this indicate that this iPhone was, I guess, paired to the vehicle?
That's correct.
Okay. And so in your experience, if your phone is paired to your vehicle and Bluetooth is on and it connects, that typically happens automatically when you get in and turn it on with your phone's with you?
Yeah, if there's a device that is registered, paired to the vehicle, it will automatically connect to that vehicle.
And finally, I just want to ask about, you had mentioned in your direct testimony that there's sometimes you can get location data. Were you able to get location data from the vehicle?
From the infotainment system, we had limited location data, and there was some location data recovered from the OnStar module.
And do you recall, was there any location data recovered for the day of June 7th, 2021?
There was no location data recovered on June 7th.
And in fact, there wasn't any for June 6th or June 8th either.
I'd have to verify those dates, but in this essence, on the day of interest in June 7th, there was no location data.
Your Honor, apologize, I forgot to please move Defendant's Exhibit 90 into evidence, I believe, without objection.
No objection.
No further questions, Your Honor.
From the stage, Your Honor.
Thank you. You may step down.
Thank you, sir.
Call your next witness.
The state calls Chris Wilson.
Do you swear on affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. If you would, please, sir, be seated and state your name and spell the last name. Yeah.
My name is James Christopher Wilson, Wilson. I go by Chris.
Good morning, Mr. Wilson.
Good morning.
If you would, tell the jury just a little bit about yourself, where you grew up, where you went to school, and what you do for a living, please.
Well, as I said a moment ago, my name is Chris Wilson. I grew up in Bamberg, about 35, 40 minutes west of here. Graduated school there, went to school up in Spartanburg for college. Came back to Columbia to go to law school at USC. Finished law school in 1994, worked for a judge in Greenville for 1 year, and then moved back to Bamberg where I grew up to practice law, and I've been practicing law there since 1995.
Are you going to have a solo practice in a firm?
Right now, it's me and one associate. I've had my own firm since 1998, and there have been varying associates that have worked with me, or at one time I had a couple partners, and one partner left, and then one partner moved, and so we split up as a result of that. But I've had my own practice since 98 with different people coming and going.
And what's the name of the practice?
Right now, it's Wilson Law Group.
Wilson Law Group.
Yes, sir.
Tell the jury what kind of legal work you do, please.
I do all kind of cases, but over the last 10 to 15 years, I've primarily concentrated on just personal injury cases. People that are injured in wrecks or hurt at work, tractor trailer wrecks, especially a lot of those, just personal injury cases.
Do you know the defendant?
I do.
Do you see him in the courtroom here today?
I do.
Can you point him out for the jury?
Yes, sir. Redhead with the glasses over there between Mr. Griffin and Mr. Harpootlian.
Your Honor, can the record reflect he's identified the defendant?
Yes.
Tell me how you came to know the defendant.
I've known Alec since we were in high school. I think I was a year younger than him, but Bamberg and Hampton are only about 30 miles apart. And so we had several mutual friends, people that I was closer to back then, but got to know and be around him some then. We played some ball against each other, and I think even played on the same ball team one summer. So I knew him a little bit through high school, but not much. Didn't keep in touch at all when we were in college. Started law school at the same time together, and became really close friends through law school. Lived together a little bit of that time. Finished law school. I moved to Greenville. He moved to Beaufort, and we would keep in touch some, but we were a little bit separated. And then when I moved back to Bamberg and he ultimately moved back to Hampton, we got much, much closer. Our wives had known each other through college, and so they became closer friends. Our kids grew up together. We just spent a lot of time together personally, and then he and I did a number of cases together. We worked professionally together.
So y'all become close friends over the years?
Yes, sir.
Best friends?
Yes, sir. I considered him to be one of my best, if not my best friend. Yes, sir.
You get to know his family?
Very much. Not just his wife, not just Maggie, not just Paul, but, Buster and his parents, his in-laws, his brothers and sisters, his mom and daddy. I mean, the whole family. And they knew my family, or he knew my family.
Y'all did things together socially?
Yes, sir. We had kids the same age. Our kids are close. We did a lot of things together, and we worked together.
Up until about June of 2021, did you talk to the defendant almost every day?
Yes, sir. I didn't see Alec all the time, not every day, maybe not even once a week, but we talk by phone probably pretty much every day, several times a day sometimes. Sometimes just about, Gamecocks and football and baseball and whatever, sometimes about kids, sometimes about business, sometimes about cases we were working on, just all kind of stuff.
Did you feel like you knew him pretty well?
I did.
You mentioned y'all worked some cases together. How many cases together did you work over the years?
Well, my firm, when I first started out by myself, was smaller. I didn't have a lot of resources. I was just getting started. His firm was bigger with a lot more resources and a lot more lawyers. They handled some bigger cases that I really wasn't capable of handling together on my own. And so when it first started out, I was associating him and his firm a lot more often, probably over the course of, these last 20 years, probably 25 or 30 cases. But it slowed down. I mean, as my firm got bigger and I became more experienced and could handle a lot more things on my own, it was less and less often that I would associate his firm. But if I ever felt like it could benefit my client with either the type of case that I was handling or where the case was going to be brought to have his firm involved, I would call Alec.
How many times do you think you worked a case with him or shared a case with him over the years?
Probably 30, maybe more.
When did that start, you think?
I opened my own, I didn't do it any until I opened my own office in 98. And I don't remember exactly when he moved back to Hampton from Beaufort, but it was probably starting in the early 2000s or somewhere thereabouts.
And were all of these plaintiff's cases where y'all are representing a plaintiff who had had some alleged injuries or something like that, or suffered some sort of harm?
Yes, sir. I mean, there may have been, one or two here or there that was something different than a personal injury case, but almost everything was personal injury cases.
And were all these cases worked on contingency?
Yes, sir.
And can you explain to the jury what a contingency is, how a lawyer gets paid with a contingency type case?
Sure. A contingency fee is basically the attorney and the client enter into an agreement on the front end of the case. When the client retains the attorney, there are no attorney's fees up front. There's no prepayment. There's no hourly billing arrangement. Basically, the attorney has an interest in the case, so that when the case resolves, the attorney receives as a fee a portion of the recovery. Generally, it's a third, sometimes 40%, depending on whether suit has to be filed or what type of case it is. But basically, the lawyer is taking all the risk in pursuing the case. If it doesn't work out well, the lawyer doesn't get paid for their time, and generally the lawyer fronts all the cost in pursuing the case for court fees, depositions, experts, all of that type of stuff. And so at the end, if there's a recovery, the attorneys repaid their fee contingent on a successful outcome and repaid whatever costs are advanced in the case.
Those costs and expenses, the cost of litigating the case, hiring an expert, travel, taking depositions,
Yes,
court
sir.
costs, things like that.
Yes, it gets very expensive.
Do those come out of the lawyer's 33% or 40% of the recovery, or are those recovered separately from the lawyer's fees?
Separately and in addition to the fee.
In the cases that you've worked with Alec over the years, was he with PMPED during those cases?
Yes, sir. I don't believe I associated him on any cases when he was in Beaufort. It was not until he returned to Hampton.
If you are in your firm and Alec is in his firm and y'all are sharing a case and ultimately you're successful, there's a settlement, there's a trial verdict, and you get a recovery, how do you go about splitting that fee?
All of that's agreed to up on the front at the beginning of the case. So for instance, a client comes in and hires me for whatever reason, whatever type case. If I look at it and decide that I could use some help, either because there's a lawyer that knows that area of law better than I do, or maybe they're more local to the case, or maybe I just need some extra manpower, whatever it is. When I associate that lawyer and his firm, we make an agreement at the beginning as to what the fee split will be, and the client approves that and signs off on it. It's generally 50-50 on almost all the cases. I think on every case I ever worked with this firm, it was a 50-50 split on the fees.
In those cases that you worked with Alec over the years up until one at the end, did your office typically handle the disbursement of the fees when the settlement money came in?
Yes, sir. I mean, I've gone back through all my files, and with the exception of one or two cases that I think were a little bit different than normal, his firm had part of the family who had lost a loved one, and I had part of the family that had lost a loved one. And instead of them having a dispute about who was going to control and handle the case, we decided to work together, and so the firms worked together.
Reimburse costs in one check together, or would you write two separate checks?
Starting out, I think we would include, not just for his firm, but for my firm, fees and cost would be in the same check. And then, more than 10 years ago or so, and maybe even longer than that, we started doing it in two separate checks just to keep the accounting of it easier, to keep up with what part of payment was fees and what part of the payment was cost. So, over the last 15 years, it's been two checks.
Do you have a staff member who helps you? It's kind of your main staff member that might handle some of these disbursements?
I have several different staff people that help me handle cases and disbursements. I have a bookkeeper that keeps up with the checking accounts and writes all the checks that I instruct her to write. And then I'm the only person with signatory authority. And I have a staff member that helps me work cases and actually helps me put together disbursement sheets and check medical lien balances and who's owed what money and those type things.
And who is that person you're referring to?
Vicky is the person that helps me do all of that.
Do you ever have called to work a case with the defendant involving Mack Trucks?
Yes, sir. I contacted Ellick and his firm to get involved and work with me and another lawyer on a case involving Mack Trucks.
All right, and tell the jury just a little bit about the case without getting into too much detail. What kind of case was it?
Sure. So lawyer contacted me about a wreck that a client of his had been involved in. A drive shaft out of a Mack truck had fallen into the interstate as the vehicles were traveling down the road. This gentleman's vehicle, along with a bunch of other vehicles, hit this drive shaft, and he was injured. And so this lawyer, it was a trucking case when he first contacted me and looked at it, and that's a lot of what I do. So he called me for some help with that.
Okay. And so you got involved in this particular case?
I did.
As you looked at the particular case, did you decide to involve the defendant?
I did. Very quickly after looking at it, this other lawyer and I both realized that this case was probably a products liability case, that the drive shaft shouldn't have just fallen out of the truck for no reason like that, and that there might be something to do with a defect in the truck. And we found some information about a recall or a potential recall, and I knew that's what Ellick and his firm specialized in, those type cases. So I called him and asked him to get involved. We were pushing some deadlines to bring in all the parties that we needed to. So it was important to get somebody involved in it fast that knew what they were doing.
And did he agree to get in on this particular case?
Yes, sir.
So you got three attorneys in there who are going to split the fee. Is that correct?
Yes, sir.
Tell the jury again, without getting too much into the weeds, tell the jury a little bit about how the litigation went. Did y'all ultimately try the case and kind of set up how y'all ultimately got to that point?
Sure. So we actually brought two cases. We brought one case for the wife of the gentleman that was injured in the wreck for what are called loss of consortium claims. That generally is just the loss of a spouse, their loss of the services of their other spouse. Maybe that spouse can't do all the things around the home they used to do, or they can't be quite the husband or the wife that they were before. So we brought a claim for the wife for loss of consortium, and we brought a separate case for the husband for his personal injuries. Not to get too technical, but the wife's case, Mack Trucks didn't answer the papers like they were supposed to. And so they went into default on that case, and that put them in a really bad spot. On the husband's case, they answered the papers and initially contested the case. But after getting Ellick and his firm involved in the case, we started doing discovery, which means we were asking for a bunch of documentation and things. And I'm not sure that they just didn't want us looking any further. And so they reached out to us, and we had communications with them about ways to try to pursue the case outside of the traditional going through all of that and going to a jury trial. COVID had hit, and so things were slowed up in the court. And ultimately, we reached an agreement to try both of those cases together in front of a judge without a jury. Both parties waived any rights to appeal. Mack Trucks admitted liability, and we agreed to waive punitive damages. I think that's the structure we tried it under.
Let me ask you two quick questions about that. You said that COVID had hit, and like the rest of the world, that had slowed up everything in court, correct?
Very much.
And, some things were moving, but because things were slowed up in court, that might slow up the ability to get verdicts and settlements and that sort of thing. To some extent, COVID had an effect on everybody. Is that correct?
Yes, sir.
All right. And then you mentioned in this particular case, you ultimately agreed for both parties to waive the right to appeal. Is that correct?
Yes, sir.
And did that have the effect of meaning that whatever verdict was issued, it wouldn't be tied up in the courts for a long time? The money would go ahead and be paid?
Yes, sir.
Did y'all eventually try that case in front of a judge instead of a jury?
We did in January of 2021, first
January.
couple weeks.
And did the defendant try that case with you?
He did.
And did y'all ultimately get a verdict?
We did. We got verdicts in both cases.
And do you remember how much those verdicts were?
Combined, they were $5.5 million. I believe it was $4 million on the husband's case. He had passed away, I believe, within about 4, 5, or 6 months of us going to trial. So I think it was $4 million on behalf of his estate for his injuries and what that had cost for him. And then I believe it was $1.5 million on the wife's loss of consortium.
Who did the closing argument in that case?
Elliot did.
For y'all's side.
Elliot did.
The defendant did?
Yes, sir.
Did he get emotional in closing?
He did.
Did he spend much time with the husband in that case?
I don't think Alec had spent a lot of time with the gentleman. He had been kind of sick towards the end, and I don't know that Alec had spent a lot of time with him. He had spent a lot of time with the wife, and especially throughout that week in trial. I mean, it was an emotional case. They had serious loss.
Closing argument, that's when the lawyer gets up and sort of summarizes the case to the judge or the jury, depending on what kind of case it is.
Yes, sir. Honestly, you do more than summarize. You argue.
You argue.
Yeah, you put your heart into it, and you tell the judge or the jury why it is you think, why it is you hope and think they do what you're asking them to do.
You said the verdict was how much in total?
5.5 million combined.
And what does that mean the fees were going to be for the 3 lawyers involved in this case?
I don't remember the exact split for everybody. I know that my fee was going to be like $791,000, and the fee payable to Alec's firm was going to be $792,000.
And do you recall?
And I
when
don't
y'all-
remember the third attorney right off the top of my head.
Do you remember when you received that $5.5 million into your trust account?
Yes, sir. Part of it came in by wire, but it was a smaller part. And I want to say that was we tried it in the first part of January. The judge didn't issue a ruling right on the spot. It took a couple weeks for him to issue his ruling, which is normal. And then within a couple weeks of that, after some back and forth with Mack Trucks' attorney about whether they were going to file any kind of post-trial motions, or they could have tried to file an appeal and see where it went, even though we had an agreement up front. We were worried that they might get around that. But anyway, after a couple weeks of back and forth, and a wire was sent for part of the money, right, probably middle of February, and then shortly after that, a check arrived for the rest of the money.
Do you remember when that was?
I don't remember exactly. I want to say the last few days of, no, it's probably the last few days of February, somewhere around in there. 2021.
Hold on one second.
Your Honor, for the record, I just want to object to this line of questioning under 404, 403, and to this exhibit. I do not have any additional objections other than those that were previously made.
I don't know what the exhibit is.
Sure.
Your Honor, this is just a text, but it's related to the in-camera matters that have been addressed.
Admitted over objection.
All right, I'm going to show you what's been marked as admitted into evidence as States 450 and see if you recognize that document, please.
Yes, sir. This looks like a snapshot of a text string that I would have provided that is just communication between me and Alec.
All right. And in the middle of that particular text, that particular page, there's some text, and do you see the date on that?
March the 10th, this would be 2021.
All right. And that's a text from the defendant, is that correct?
Yes, sir. It looks like we had been talking about getting together to play golf. And then he texted me, you want me to read it?
Go ahead and read that to the jury, what your text conversation right there is.
March 10th, I need to get checked today. If it's just too much for you, I will deal with it.
All right. And what's your response?
I'm working on it.
So that's March 10th of 2021, is that correct?
Yes, sir.
May I have the Elmo, please? All right, well, let's talk about that text a little bit. So does that text help you kind of get an idea of roughly when the disbursement check came in on the Mack truck case?
Yes, sir. So by our rules, the Supreme Court, any check that's of a certain size has to be in your trust account for at least 10 days before you can disperse. And this was a sizable check, so I was going to wait more than 10 days just to make sure there weren't any problems. So if that's March the 10th, like I said, those checks, the final amount of that money would have come in sometime, towards the end of February. Because I think I waited 12 to 15 days, as I recall.
You said it's a sizable amount of money. This was a pretty big recovery, correct?
Yes, sir.
I imagine you contacted the other attorney and you contacted the defendant to say, hey, got the money in.
I did.
Did you when you contacted the defendant about that, what, if anything, did he say?
Great news, good. I told him that I was going to sit on it a little bit longer than normal to disperse, just because if it had all come in a wire, I could have dispersed immediately because those are considered received funds. But with it being a check, I wanted to wait. And so I let both of them know that I had received the money and that I wasn't going to do it on the 10th day, but that I would do it shortly thereafter.
Did the defendant ask you to do anything when it came time to dispersing his firm's share of the funds?
He did, yes, sir.
All right, tell me about that conversation.
When it came time to disperse the checks, and I was calling him and the other lawyer to let them know that I'd have the checks ready, I guess somewhere around March the 10th, Alec told me that he was going to put the monies into an annuity, that he was going to put his fees in an annuity. He called it a structure, but in essence, he explained he was going to put those monies into an annuity, and that the checks needed to be made payable directly to him instead of to his firm so that he could do that.
Okay. And did he explain to you why he was going to do that?
He had just indicated that he was putting money away. He indicated he was concerned about the boat case, and that he was going to put some monies in an annuity or into a structure.
You say he was concerned about the boat case. What exactly what was he concerned about? What did he tell you he was concerned about?
He was concerned about his exposure in the boat case.
In a civil lawsuit?
Yes, sir.
And you were aware that the defendant had been sued civilly in the boat accident case?
I didn't know if he had been sued himself, but I knew there was a lawsuit going on involving, and I believe I did know that he was himself sued at that time. Yes, sir.
So this was different than how you normally did things, correct?
Very much.
Did he have any further explanation to you as to why this would be okay? Why this was all right to do?
He told me that he had already cleared it with the partners in his firm. I mean, he was a partner himself with the authority to do things for the firm, but he told me he had already cleared it with his partners in the firm, and that they were going to put the monies on the books and that they would be accounted for at the end of the year whenever they did their year-end settle up, that he would already be accounted for as having been paid these monies already.
Looking back at this exhibit that's now up on the screen, on March 10th, exhibit 450, he says, I need to get the check today. Is that correct?
Yes, sir.
And did he tell you any more about why he needed to get the check today?
I spoke to him on the phone that day, and he just asked me if the checks were going to be ready that day. As I recall, I was on the road. I wasn't sure I was going to make it back to the office or not. My bookkeeper was getting the checks ready. And I spoke to him on the phone and told him that if I got back in time to sign the checks, I'd have them ready that day. He told me he'd like to get them that day. Yes, sir.
He told you that he had already cleared this with the partners. They were okay with him getting this money right now instead of having to wait till the end of the year.
He told me that the partners were aware that the monies were being paid to him, that he was going to put them into annuities, and that they would be accounted for on the books of the firm as already having been credited as paid towards him.
Did you believe the defendant when he told you these things?
Yes, sir. I didn't have any reason not to.
Your best friend?
Yes, sir.
Did you trust him?
I did.
Didn't set off any red flags to you at this point?
No, sir. And I'd known him for 30 plus years and didn't have any reason not to trust him.
Did you ultimately initially write a couple of fee checks?
I did, yes, sir. I think I wrote one check in the gentleman's case and one check in the lady's case. And then the gentleman's check was rewritten into two checks. These were, when I say these checks, I'm talking about fees that were paid.
Okay. I'm going to show you what's previously been marked as State Exhibit 345. You said the total fees that were going to go to Alec in this case were how much?
$792,000
And he asked you to write the checks out to who?
to him,
Him directly,
Richard Alexander Murdaugh,
instead of what?
instead of PMPED or the law firm.
Which would be the normal practice.
Yes, sir.
All right, I'm going to show you what's been marked as 345 and see if you recognize this document. States 345.
I do.
All right, what is that?
So this is a check that was initially written to Richard Alexander Murdaugh Esquire for $600,000 on March 10th, 2021. This says fees on the bottom. This would be the fees on the gentleman's case for payable to his firm, which Alec told me to write to him. This check was voided and rewritten into two separate checks.
All right.
It's marked void.
All right, Your Honor, this time I would move to admit States 345 into evidence.
Your Honor, we do not have any additional objections to that document.
It's admitted. All right. And this check is made out for how much?
$600,000.
All right, and again, there were two cases, so there were going to be two separate checks. Is that correct?
Yes, sir. This was just the fees on the gentleman's case.
And that was going to be how much total?
Total was $792,
But this one is
$600,
and then the one for the other one,
$192.
192. Okay. All right. And so you initially write this check. Did you deliver this to the defendant, or what happened?
I didn't deliver any of the checks. I believe he had somebody pick them up that day from his office, a runner or something like that. But no, so this check was voided out, and we rewrote two separate checks made payable to Richard Alexander Murdaugh.
Why did you do that? Why did you void this one for 600 and then write two separate checks?
When I called Alec and told him, or when we were talking and I told him I thought the checks would be ready, he instructed me that he was doing three separate annuities, and so it would need to be in three checks, and that this check would need to be made out in two different checks that totaled $600,000.
A bunch of different annuities, huh?
Yes, sir. It wasn't all going into the same annuity or the same place.
So you recut into two checks, is that correct?
Yes, sir.
All right, I'm going to show you what's been marked as States 346 and see if you recognize that set of documents, please.
Yes, sir, I do.
All right, just flip through it real quick.
Can't even tell you what they are.
We'll just flip through it first, if you would, please.
Yes, sir, I recognize all of this.
All right, and tell the jury what those are, please.
So the top document is the $192,000 check dated March the 10th, 2021, made payable to Richard Alexander Murdaugh Esquire. And on the bottom, it says fees. That would have been the fees on the ladies' loss of consortium case.
Okay.
The back of it, the rest of it's just the back of the check. Looks like it's endorsed Bank of America deposit only. A signature that looks like Alec, but it's kind of scribbled and says Bank of America.
Okay.
The next page is a check for $225,000 dated March 10th, 2021, payable to Richard Alexander Murdaugh Esquire. And on the bottom, it says fees. This would be part of the rewrite of that $600,000 check. Same type of endorsement paperwork on the back. And then the third check is a check dated March 10th, 2021 for $375,000 made payable to Richard Alexander Murdaugh Esquire. And on the bottom, it says fees. And that would be the second part of the rewrite of that $600,000 check for the fees in the gentleman's case.
Your Honor, at this time, I would move to admit States 346 in evidence.
We don't have any additional objections, Your Honor.
They're admitted.
All right, I'm going to show you what's been marked as States 347. See if you recognize those two documents, please.
I do.
All right, tell me what those are.
So these are two checks from my firm made payable to Peters, Murdaugh, Parker, Ellsworth, and Dietrich. The memo part is redacted, but I know what these are. So these were cost reimbursement checks in both of these cases. One check for the gentleman's case and one check for the wife's case. They're dated May 13th of 2021, made payable to the law firm. One of them is for $14,619.13, and one of them is for the same amount except for 14 cents.
All right, tell me the date on those expense checks, please.
May 13th of 2021.
And go back if you would, and let's again remind the jury what the date of the fee checks are, particularly after they were recut at the defendant's request.
March 10th of 2021.
Let me put these up on the screen real quick. Your Honor, I'll move in States 347, please.
No objection.
They're admitted.
All right, we're at States 346, and this is the check for $192,000. Is that correct?
Yes, sir.
And the date is March 10th. Is that right?
Yes, sir. That's the day that all three lawyers' checks were cut to be paid.
Same date of that text the jury's seen, correct?
Yes, sir.
Next page, this is the check for how much?
$225,000.
And that's part of the 600K.
Yes, sir.
Same date.
Yes, sir. March the 10th.
And that's your signature on there.
It is.
Going back to the first one, you said that looks like whose handwriting?
Yes, sir.
Whose?
Alex.
Right there on the second check on the back. That looks like whose handwriting to you?
I mean, the top left of it looks like Alex's signature.
Okay. And then finally, this last check, that's the 375, this part of the 600,000.
Yes, sir.
Is that your signature right there on the check?
It is.
And the same date?
Yes, sir. March 10th.
And do you recognize that signature at all?
I mean, it looks like Alex, but I mean,
Best as you can see on this
best I
document.
can tell. Yes, sir.
Okay. All right. What, those particular checks, what did you, once those were cut, yeah, the defendant's been texting you about it. What did you do? Once you recut them?
I think, as I said a little earlier, at some point in time, we were having a phone conversation, and I told him that I was on the road, that if I got back and was able to sign them, I'd let him know. And I ultimately did make it back to the office, I believe, that day, was able to get the check signed, and either called him and said they're ready, and he said, I'll send somebody up to get them, or maybe I called him as I was going back to the office, but before I actually signed them and said, hey, I will be back to sign them and they'll be ready. And he said, well, I'm gonna send somebody up to get them.
Okay.
And so they would have come up. I think he had a runner come up that day that would have picked up a package that had those checks. I don't remember exactly for sure, but generally it's going to be those checks, a cover letter, and a package that has a partial disbursement sheet. Our client had signed off on allowing the fees to go ahead and be paid. Then, while we were waiting on some liens to resolve themselves, some costs to come in, and some things like that. So our client had signed off on a partial settlement statement, and I would have provided that.
The voided check we saw before, and these checks all have the same date. Is that correct?
Yes, sir, they do.
All right. And do you recall anything about that? Did you call him up and say, hey, great news, I got it taken care of? He said, wait. How did that go down?
I don't remember. I don't remember how many different conversations we had that day, whether it was over, one conversation or two conversations. I don't remember. But at some point, he instructed me that the $600,000 check needed to be made into separate checks.
You sent somebody to pick
I
them
think,
up?
I didn't mean to cut you off. We talk a lot every day. And so we probably had multiple conversations that day. But at some point he instructed me to do that.
He's one of your best friends.
Yes, sir, very much. Not just my best friend, Mr. Waters. Our families were close. Our kids, our wives, we're close.
You had a friendship with Maggie too.
Yes, sir, very much.
You had a friendship with Paul too.
Yes, sir.
You had a friendship with Buster too.
Yes, sir. Haven't been able to have that since. Not like it was, but yes, sir. Hope to one day. But, yes, sir.
Why didn't you disperse the fee checks the same day? Do you recall?
The fee checks were
I'm sorry,
dispersed.
my bad.
Cost
The
checks.
expense checks, the cost checks.
Yes, sir. We were still waiting on some costs to come in, and we had several experts in that case. And it's not abnormal to have costs that come in after a settlement or after a verdict that you reach. Sometimes you're taking depositions up to the last minute. Sometimes you have experts that are working. They're going to send you their bill for their trial time. And so a lot of times those costs will come in. I think our client had authorized us to hold some money back in escrow for an expected cost. And so we had a lot of bills that were coming in even into late April.
You mentioned that the defendant had said something about his exposure in the boat accident lawsuit as a reason for structuring these fees.
Yes, sir.
Did he say any more about that?
Not in that conversation. When he asked me to write the checks directly to him, we had some other conversations, and I don't remember if they were before this or after this. I think they were after, but I don't remember for sure, where he had just said that there was, some fights going on between insurance companies.
When the defendant asked you to do this unusual step and write the fees direct to him, and you said you trusted him, correct?
Yes, sir.
What was your general perception of his law practice, of his wealth, of his financial security, knowing him as well as you did? What was your perception of that?
Big firm, big reputation. Alec had a big reputation. I thought he made a whole lot more money than I did. Everything I knew from the way his partners treated him, the type of cases I saw him working on with them, the type of cases I knew he worked on with me, that he was, one of the biggest dogs in that firm, one of the biggest producers they had. Seemed to own a lot of things, do a lot of things, spend money. Didn't ever seem to have problems. And I knew I was associating him and his firm on very good cases throughout the years, and I knew other lawyers that were. It seemed like they were doing very well, and that he specifically was doing very well.
And is that perception that you had of him one of the reasons why you trusted him? that there was no shenanigans going on?
I don't know that that's the main reason. I trusted him because I knew him and had dealt with him personally and professionally for a long time. But I had no idea if he was having money problems. I mean, I would have never suspected that his asking me to write checks to him had anything to do with money problems on his behalf. Nothing gave that appearance. So, I mean, that could have factored into the back, but mostly it's just I knew the guy and I trusted him. And he wasn't asking me to do anything that raised any flags with me. He told me he had cleared it with his firm and with his partners. I didn't have any reason to doubt that.
I'm going to put States 347 up on the screen. And what are these again?
That's a cost reimbursement check in one of those cases. I can't tell you which one it is.
All right. And then if we go 2 pages back, this is the other check.
Yes, sir. In the other case, cost reimbursement.
All right. And those are the same amount.
1 penny difference. I think Alec sent me the cost total and I just split them evenly between the 2 cases.
And what's the date on that check, those checks?
May 13th of 2021, which I believe would be the time, obviously, we wrote the checks and they would have been mailed to his office shortly thereafter.
And you said that there was a reason why these came a couple months later?
Yes,
So
sir.
we're waiting for some information?
Waiting on costs to finalize up. Instead of writing multiple checks as costs came in, we just kind of wait sometimes till the final bill's received.
Is that your signature on these checks?
Yes, sir.
And those would have been mailed to Alec's law firm, correct?
That's the general practice, yes, sir, is we mail them to the firm. And I don't know any reason why these wouldn't have been done differently.
In May of 2021, did your office, after these checks were mailed, did your office receive any communication from the defendant's law firm?
My paralegal, Vicky, received an email from Alec's paralegal,
Okay.
Annette.
And tell me about that. What was the communication? It was received from Annette.
Yes, sir, from Annette Griswold, Alec's paralegal.
Right. Your paralegal, Vicky, received a communication from Annette Griswold, the defendant's paralegal.
Yes, sir. Vicky got an email from Annette that said, hey, we got the, something to the effect of, hey, we received the cost checks, either why no fee checks or where are the fee checks.
Okay. And did Vicky respond to that?
She did.
What did she respond?
She responded to Annette that the reason the fee checks weren't included is because they had already been paid to Alec, that he had already received the fee checks.
Was that on about May 19th, 2021?
I'd have to look at the email, but I believe so. Yes, sir.
Did Vicky raise any issue with you at this point? Did you know anything about it at this point?
No, sir. I was preparing. I was in trial the following week in Hampton, actually all week long, and I was preparing for that. Vicky sent that email back. She didn't notify me about that actually until all this blew up, and I turned all that over to SLED after we found it, after all this blew up in September.
Moving into late May 2021, did this matter that Annette was raising with your firm come to your attention?
It did.
And tell
And
me.
it wasn't late May. It was the first part of June.
I'm going to show you what's been marked as Exhibit 348. Let's take a look at that real quick before we move on.
Sure.
See if you recognize that.
I do.
So tell me what that is.
So this is an email string that begins on May the 27th from Jeannie Seckinger, which is the bookkeeper or accountant in Alec's law firm. And it's an email from Jeannie to Annette Griswold, Alec's paralegal, on May the 27th, where she telling Annette that she got the expense checks and it didn't match their records, that Alec thought he had more outstanding costs, but can't say what, and was asking Annette to reach out to my office, to Vicky, to get some more information. And then it looks like Annette forwarded that email to Vicky on May the 27th. Vicky was on vacation, and did not come back in until the following week. It looks like she emailed her again on June 2nd. Vicky might have come back in on like June the 1st, or I think May the 31st was Memorial Day, a Monday. And so June the 1st was then when Vicky came back in. So Annette emailed her again on June the 2nd and asked for some information. And then Vicky emailed her back and said, since this involves documents she didn't deal with, which was bookkeeping stuff that she didn't deal with, she would forward it to me.
And so that happened on what day?
June the 2nd,
Of what year?
2021.
Your Honor, this time I'd offer states 348 in the evidence.
No additional objections, Your Honor.
Admit it.
All right, and so this is going to the bottom. This is the email from Jeannie to Annette. Is that right?
Yes, sir.
And then that gets sent from Annette to Vicky on May 27th, correct?
Yes, sir.
And then she gets back from vacation, and then she responds on June 2nd, 2021, correct?
Yes, sir.
And what does she say?
She's going to forward that to me. And she did. She CC'd me up in the email stream.
All right. And did you have a conversation with Vicky at that time about this issue?
I did.
What'd you tell Vicky, or what was y'all's conversation?
She said, I've gotten this email from them asking about the cost in this case. What do you want me to do? And I said, tell them that you'll forward it to me and I'll deal with it.
Around this time, had you had any conversation from any other partners in PMPD, the defendant's law firm?
As best I recall, Mr. Waters, I was in Hampton the entire week before, and I was working out of their office. I was trying a case down there like the week of May the 24th, and I was working out of Alex Firm's office. Lee Cope approached me and said, hey, I need to talk with you about this Mack Truck case. Has all the money been dispersed? I said, Lee, it hadn't all been dispersed. We've got some liens, some medical liens we're waiting on to deal with. We've got some costs that we're waiting on to come in, and it all hadn't been dispersed, but I don't know off the top of my head. I'll have to check on it. And I was stuck in trial through Friday of that, or through Thursday of that week.
Did you reach out to the defendant after Lee had that conversation with you?
I reached out to him after I got this email.
All right. And tell me what your conversation was with him when you reached out to him, having received this email from Vicky asking about these fees.
I called Alec. I said, Alec, I got this email from your firm. They're asking about issues with costs that you think you've got more costs that are owed to you. I put down on the settlement statement and wrote checks for the amount of costs that you gave me. But if there are more costs outstanding, just figure out what they are, because we've been holding some money back. And I think at that point we were waiting on a medical lien to resolve. And I don't think the client will have a problem paying the cost out of what we're holding back.
Did you have any discussion about the disbursement of the fees at that point?
I did. I said,
tell me about that.
I said, Alec, this is the case that you asked me to write the fee checks directly to you. Is everything all right? And he said, yeah, everything's fine. I just need to make sure my partners know that this is the same case, that you wrote the checks to me and that it's already on the books.
Did you believe him?
Yes, sir.
After you had that conversation with the defendant, did you do anything else, or did you think it was handled? Because you had spoken to your best friend, Alec Murdaugh.
He told me it was taken care of. He told me he had talked with his partners about it. I didn't think there was any other problem. I didn't do anything else.
A couple of weeks later, did you have another conversation with him about the same issue?
Yes, sir. This would have been after June the 7th. Yes, sir. And it might have been more than a couple of weeks, because I didn't ask him anything after Paul and Maggie. I didn't want to. I asked him if everything was all right, and he said it was fine.
When you got that email forwarded to you from Vicky on June the 2nd, did you call Alec that day?
I think it was, I didn't mean to cut you off, but I think it was that day.
Thereabouts?
Yes, sir.
Remember June 7th, 2021?
Yes, sir.
Is that a Monday?
Yes, sir.
Gamecocks had played some baseball that weekend. You'd
Yes, sir.
seen the defendant?
I'd seen him and Maggie and Buster, my wife and I, and our children, had been with him and Maggie and Buster the weekend before Saturday. Yes, sir.
On Monday, June 7th, 2021, what was your day like during the day?
Went to work. I was in the office most of the day. I think I had something scheduled that it canceled out. And ate lunch with a friend. And I live in Columbia, even though I practice in Bamberg. Kind of later in the day, I ran by the pharmacy, picked something up, and then headed to Columbia and stopped to pick something up at the store on the way home.
Went home,
Yes, sir.
normal evening?
Yes, sir.
Remember what you were doing that evening?
Just hanging out with my wife and, I don't remember how many of our kids were home. I think just our youngest, just watching TV.
Watching TV?
Yes, sir. I was kind of late getting home, so there wasn't a whole lot of the evening left.
That evening, did the defendant call you?
Yes, sir, he did.
About what time did he call you?
I don't remember exactly. I turned my phone records over, but I think it was around 9:20, 9:15, 9:20.
Before we talk about that, I'm gonna show you States 451. Do you recognize that?
I do. Yes, sir.
What is that?
This is my phone log that I turned over to SLED.
Does that reflect calls from Alec Murdaugh on the night of June 7th, 2021?
Yes, sir.
Tell me,
To and from, yes, sir.
tell me what you were doing when they first received a call from Alec Murdaugh that night.
I remember my wife and I were sitting on the back porch. We have a TV on the back porch. We were sitting back there on the couch talking, watching The Bachelor. Can't believe I was watching that. The phone rang. It was Alec. I had actually stepped off the porch and the pool pump is on the side of the porch and I was trying to mess with something with the pool pump. Sounded like it was running funky. And so the phone rang and it was Alec and I answered the phone.
What did he say?
Said, hey, hey, Bo is normally how he would greet you. Hey, Bo. And I don't remember if he said, what are you doing or what? I pretty quickly told him, hey, I've got my hands in the middle of this pool pump messing up. Can I call you right back?
Did he sound normal to you?
Sounded normal. Yes, sir.
So you said, hey, I'm busy right now. Let me call you back.
I did. Yes, sir.
And what did he say?
Said, that's fine. No problem.
And having that exhibit in your honor, I apologize, I'd move. States 451 into evidence at this time.
Submitted.
And having a chance to look at your phone records there, what time was that first call?
Looks like it was at 9:11 p.m. incoming from his cell phone.
All right, so you got off,
2-minute phone call.
2-minute phone call.
Yes, sir.
So you got off the phone, what happened next?
I finished trying to fix the pool pump, called Alec back,
All right. And what time was that?
9:20 p.m.
Tell me about that conversation. Tell the jury about that conversation.
Called Alec back. I generally say, hey, Bo, too. And, hey, Bo, calling you back. He said, hey, I'm about to get to my mom's house. Can we talk a little bit later? I told him, sure. There were a couple of things I needed to talk with him about, cases that one case that we were working on and one case that I had going on. I wanted a little advice. ask him how his mama was doing. And I asked him how his daddy was doing because I knew his dad was getting a lot worse. We had talked about that over the weekend at the baseball game in Columbia. And I think we had talked on the phone on Sunday also. So he said, can I call you back or can we talk later? And I said, sure.
You said his daddy was getting worse. Had he called you that day, Monday at all, to give you any updates to your recollection?
I don't think we talked earlier in the day on that Monday, but we had talked on that Saturday before and on that Sunday before. And so I knew his father was getting worse. And I think I knew that he was either going to or had already gone to the hospital.
So that second call, was that also very brief? He said, hey, I'm at my mama's.
3 minutes.
So what happened after that? You still watching TV?
Still watching TV. Yes, sir.
Did you talk to the defendant again?
I did. He, I believe, texted me sometime later that evening. And I think the text was something, are you still up or still up? Something like that.
All right, stand by for me real quick.
Sure.
I'm gonna show you what's been marked as States 452 and see if you recognize that document.
Yes, sir. This is a snapshot of text communications between me and Alec that I snapshot and provided.
All right. Your Honor, this time I'd move States 452 into evidence.
No objection.
Submit it.
452. This is a screenshot of the text that you, of your text that you provided. Is that correct?
Yes, sir.
All right. And we see down at the bottom, is that a text? Who is that text from?
That's from Alec to me at 9:52 on June the 7th. It says, call me if you up.
Okay. Did you receive that text? Were you still awake at that point?
Yes, sir, I was.
All right. And what did you do?
Picked up the phone and gave him a call.
Okay. And tell me about that conversation. Called him one time or two times?
No, I called, the first time I called, he didn't answer, which is kind of normal with Alec sometimes. Sometimes he wouldn't answer because he was either on the phone or sometimes he was just in bad service, I think, and couldn't get a call to go through. So I'm pretty persistent. I call right back. So I called him, I didn't get an answer, and then I called him back. And that was at 9:50, according to these records, 9:52 is when I tried to call and didn't get an answer, and I called back at 9:53 and said, hey, Alec, I got your text calling you back. How's your mama? And he said, she's, doing about like normal, I think. I mean, she'd been doing poorly for years. And I told him I needed to talk to him. We had a case we were working on that involved a piece of equipment that had malfunctioned. And the company had preserved the equipment, but they weren't going to preserve it too much longer. We needed to get it inspected. And they were kind of pushing on us about when the inspection was going to occur. And I said, hey, we need to talk about this and get this squared away so we don't miss the chance to inspect this equipment. And I need to talk to you about some motions or something I've got upcoming that I need a little help on. And he said, hey, that's cool, but I'm about to get back home. Can we talk tomorrow? And I said, sure, fine.
That was some total of what he had to say was he's about to get home to Moselle and can we talk tomorrow? Correct?
Yes, sir.
We put States 451 up on the screen. Right here, is that your writing right there?
That's my handwriting. Yes, sir.
And that says Alex M. And those are the defendant's calls. Is that right?
The bottom one is him calling me and me telling him I'm on the pool pump. The next one is me calling him back and telling me he's about to get to his mama's. And then the next one up here is me trying to call him after that text that he didn't answer. And then the top one is me calling him back after he didn't answer and talking to him for those couple minutes.
All right. And then that one in the middle, that's just a irrelevant conversation with some other person.
Just a friend of mine who I told his name was probably coming out today. So I told him that he was on my phone.
We did scratch out his number.
That's right. Yes, sir.
Now we did.
Yes, sir. I felt like his name would probably come up today, and he should know that.
Just go about your evening after that? Did you just go about your evening after that?
Pretty shortly after that, I went on to bed. My wife stayed up, but I went on to bed shortly after that.
How'd you find out?
I was asleep. My phone's always kind of sit beside the bed. I could hear it buzzing, but I really wasn't paying any attention. My wife comes in kind of, just hysterical. She says, "You got to wake up. You got to wake up." And I don't remember if she was on the phone with Randy's wife or Randy himself. She's trying to tell me what's going on, and I'm looking at my phone, and I've got a text from a person I knew in Hampton that's texting me saying, "Hey, give me a call. I got to tell you something before you hear it somewhere else." It was the person that was in the county government down there that I knew that was just trying to get word to me before I heard it somewhere else. My wife, I don't think I respond to that person or her text immediately. My wife is telling me what's going on. I just told her, I said, I'll get some clothes. I got to go to Moselle. We started trying to call our daughter right at about 11 o'clock. Started trying to call our children, tell them what was going on. I don't even know how much my wife and I spoke about it. I mean, she knew I was leaving. I got in the car, I went straight to Moselle, grabbed some clothes and went straight to Moselle.
So how long does that take?
From Columbia, about an hour and 40 minutes or so. I mean, I called some different people on the way that I thought needed to know. I mean, repeatedly tried to call my daughter. She was extremely close. She is and was extremely close to Buster and Paul. And, we couldn't get her to answer, called her boyfriend, just repeatedly calling her. I think I talked to Randy on the way down, but I can't say for sure I did, but I know I talked to somebody in their family on the way down just to tell them I was on the way.
About what time did you get to Moselle?
About 1 o'clock in the morning.
Other family and friends were arriving then too?
Already had arrived, I believe. Yes, sir. I mean, when I got there, I went through the main gates. I could see, I don't know that I knew at that point that this had occurred at the kennels, but I could see that there was tons of activity there as I passed by to go to the main gate. And when I turned in the main gate, I was on the road headed up to the house. You don't go very far and you can turn right to go to the kennels. I almost was going to turn and go down to the kennels. And I think John, Marvin, and Randy were walking out and kind of waved off and said, "Go to the house."
Is that where you went?
Yes, sir.
Was the defendant there?
He was, yes, sir. Yeah,
You talked to him?
I did. I walked in, hugged his neck and cried. Didn't know what to say.
Hugged his neck and cried.
Yes, sir.
A lot of people there coming out to support him as you would expect, correct?
Yes, sir. There were a lot of the lawyers that he practices law with, several family members, some friends of his that I knew. There were a lot of people already in the house, yes, sir.
Did you stay there during the early morning hours as a friend, supporting your friend?
Yes, sir, till 5:30 or so in the morning. 4:35, I don't know. Everybody was shocked and destroyed, and times it felt like it stood still. So I don't know exactly what time it was, but sometime 4 or 5 o'clock that morning, everybody decided it would be best for Alec and Buster to go get some sleep, or at least try to, and not stay there that night. And so I went back to Bamberg and slept in my office.
Did you return to Moselle the next day after getting some sleep?
I did about 9 o'clock that next morning.
Were you there as much as you could be at Moselle or wherever you were needed over the next few days in the aftermath of all of this?
Yes, sir. I was there almost entirely the next 2 days.
At any point, did you ever have any conversation with the defendant about what he did that night?
Not really, no, sir.
What do you mean by not really?
I didn't ask him. I didn't want to know what he found. I didn't want him to have to describe that to me. I didn't want him to have to relive it. So I didn't ask him about it.
Didn't ask him.
No, sir.
It's only natural.
Yes, sir. I was there as a friend, supporting him and his family. I didn't need to know the details. I knew all I needed to know is that two people that I loved were gone.
Certainly we're going to ask him about the stupid issue with the fees in this time.
No, sir, not at all. Didn't know there was an issue with the fee. I did not know there was an issue with the fee at that time, so I didn't have anything to ask him.
Over the next few weeks, did you do what you could do to be a supportive friend?
I did. Yes, sir. I tried to call him even more often. If I was anywhere close to Hampton, I tried to stop by and check on him. Tried to make him go places and do things. Not much, but I felt like he needed to get out. I was worried he was going to hurt himself. I was worried he's going to kill himself, just like I think a lot of people were, family and lawyers, his partners. And so I think we all talk regularly about keeping an eye on him, about being there for him.
After a few weeks go by, the shock starts to abate just a little bit.
It still hadn't abated.
Still hasn't abated, just a little bit.
Yes, sir.
At some point, does the defendant call you about those fees?
He does. Yes, sir.
You remember roughly when that was?
Sometime around the middle of July.
What does the defendant say to you?
He tells me that he has not been able to put the monies into the annuities like he thought he could, that he's messed it up, and that the monies need to be paid to his firm, and that he needs to send the money back to me to run it through my trust account to write the checks to his firm directly.
You remember how that conversation came up?
I don't remember exactly how it came up, no, sir.
But he contacted you to say, hey, I messed up those annuities. I need to send the money back to you, correct?
Yes, sir.
Did he send the money back to you?
Not all of it, no, sir.
What did he send back to you?
600,000 of the 792.
And in what form did he send that money back to you?
It came in the 600,000 came in two separate wire transfers.
Tell me about those.
I don't remember the dates, but I think it was July 15, July 16, somewhere around in there. One came from Palmetto State Bank, and I think one came from Bank of America.
One for $350 and one for $250, correct?
Yes, sir. I believe that's right.
That was only $600,000, correct?
Yes, sir.
And you had dispersed to him directly how much?
792,000.
Did you have a conversation with him about the fact that it was $192,000 short?
Yes, sir.
And what was that conversation?
Told me that he had already put the 192,000 away to where he wasn't going to be able to access it. I took it that he had already put it into the annuity and that it wasn't going to be available without some type of penalties or cost. And he said, I don't have the 192, but I'll be able to get it to you very shortly or soon. I don't remember if he said within a couple of days or a couple of weeks or what he said, but it was soon.
What did he want you to do, though, once this money came back in? Did he ask you to do anything?
To rewrite the checks payable for the fees to his firm.
Did he ask you to communicate with the firm at all?
He asked me when the money was back into the account, if I could send an email that I was holding those monies so that they would know those monies were in the trust account.
But you're $192,000 short, so what was his discussion then?
He told me he didn't have the $192,000. And I mean, at that point, I know that I've got a trust account for which I'm responsible for. I've got money that's supposed to have been in my trust account payable to his firm for fees. That's my responsibility. And so I had to put $192,000 of my own money into my trust account to hold for the fees for his firm.
And how did you do that? How did you put $192,000 of your own money into your trust account to cover the defendant?
I wrote a check for myself and put it into my trust account.
And just quickly explain to the jury why you have to do that. What is it about a trust account that you have to do that if you're going to send that email to the firm?
Because I can't tell somebody I'm holding money in my trust account that I'm not holding in my trust account. I'm responsible for that trust account. Trust accounts are money that belong to someone else that you're holding in a fiduciary relationship, and you're responsible to make sure that those monies are held and dispersed appropriately. And at this point, I'm hearing that I haven't dispersed or paid those monies the way they're supposed to be paid.
At that point in time, did he ask you to cover that money, or was that just kind of a given that he was short?
I knew I had to, and I think he asked me to, but I knew that I had to.
So you get the $600,000 from the two wires, and you write $192,000 of your own money,
Yes, sir.
and then you send an email to the law firm. Is that right?
I sent an email to Alec, yes, sir, that he tells me he's going to forward to his firm, which I, ultimately found out that he did forward to the bookkeeper and one of his partners.
I'm going to show you states 349 and see if you recognize that.
Yes, sir. This is an email I sent on Monday, July the 19th, 2021 to Alec.
Is that the email you're talking about?
Yes, sir.
All right, this time I've moved states 349 into evidence.
No additional objection.
Admit it. Can you read that email to the jury, please?
Sure. Alec, as discussed, I'm confirming that I am holding in trust $600,000 in the, and that's just redacted to take the gentleman's name out, the gentleman's case, and $192,000 in the, and that's redacted out to take out the wife's name, in the wife's case, which represent attorney's fees.
After you sent that email, did the firm contact you? Did you have to disperse the money, or did that just kind of end the matter?
Not until September the 3rd, when Lee Cope called me after they claimed it, after they say that they had discovered that Alec was stealing money.
Well, let's talk about the interim. But at that point in time, you sent that email and nobody's making any further inquiry at that point in time. Is that correct?
No, sir.
And that money's just sitting there,
Sitting in my trust account.
including your personal 192 that you wrote to cover Alec, correct?
Yes, yes, sir.
Did you ever have a conversation with Alec about when he was supposedly going to get you that money?
Yes, sir.
Tell me about that.
I know we talked about it one time. I think it was at the August convention down in Hilton Head that most of the lawyers that do what we do attend. I had begged Alec to come down there and for Buster to come with him at least one day to play golf with some of us so they'd get out and do something so Buster could do something normal. And I think it was while we were playing golf that I just said, hey, where we stand on you getting me repaid. He told me that, I knew that Maggie's estate would be tied up. And I figured that that was a delay. He told me that he was, moving towards selling some property and that his father had obviously just passed and that there would be some money coming to him from his father's estate and that he was working on it. And he was trying to do it as quickly as he could. He apologized for it taking longer than he said it would.
And he told you that he had tied up some money in structures or something like that, and that's why he couldn't get to it right then?
That's what he told me, why he couldn't get the 192,000, because that he had already put it into, the way I understood it, he had already put it into the annuity and couldn't get it back out. I think once you put those monies away, is my understanding, is you can't just pull them right back out. It's not like a checking account or a savings account where you can deposit and withdraw immediately.
But that's what he's explaining to you, right?
Yes, sir.
So that conversation you had with him at the trial lawyers conference playing golf, that was when, roughly?
First weekend in August. Actually, it'd probably be that, we normally try to play golf on that Thursday, so whatever the first Thursday in August is.
Not long after that, did you have another conversation with him about the money that you had covered for him?
I did.
And roughly when was that?
Sometime shortly after that, middle of August, maybe, I called him up and said, I need to come see you and talk to you about something. And I went down and talked to him about this money. But it wasn't it was about the money. I needed to be repaid. That's a lot of money to me, and I wanted to be repaid.
$192,000, that's a lot of money.
Yes, sir.
A lot of money to anybody.
Yes, sir.
I'll show you what's been marked as State 350. You recognize that?
I do.
What is that?
So
What's the date on that first?
August 17th of 2021.
Your Honor, at this point, I'd move States 350 into evidence.
No objection.
It's admitted.
All right. Tell me about that document. What happened? What's your conversations related to that document?
At some point in time when I'm talking to Alec, I said, hey, I need to come see you in your office and talk with you about something. I don't even think I told him exactly what it was. He said, sure. So I went down and went in his office. I said, look, I hate to even talk to you about this and I hate to ask you this, but if something happens to you, and I think I phrased it like if you get hit by a car or something happens and you die, I can't get repaid that money against your estate unless there's something in writing between us. I knew enough to know, enough of the law to know that you can't enforce an agreement with a person that's deceased against their estate unless you got some documentation of it. I said, boy, I hate to even ask you to do this. And I was worried that he was going to kill himself, still at that point. And I was worried about what that would, mean, more so on a human personal level, but also what that would mean about me trying to get repaid. And I said, I hate to ask you to do this, but can we do this? And he said, sure, no problem. That's our agreement, and sure. And so we scratched out, he hand wrote it, 3 sentences, nothing formal or fancy.
This is on what day?
August the 17th. And I was in his office.
Hold on for me 1 second.
I'll stand for a moment. These conferences, isn't it? Ladies and gentlemen, we have you go to the jury room for recess. Please do not discuss the case.
No, I just, out of an abundance of caution, before we got to this portion of the witness's testimony, as your Honor is aware from the in-camera proceedings, there is, he has a confrontation with the defendant, and the defendant tells him some things that he, the witness here has a confrontation with the defendant at his mother's porch after receiving word about what the law firm had found. From the in-camera testimony, the witnesses testified that the defendant, admits the financial misdeeds, says he had a drug issue, I think going to rehab, and some things like that. And that is, I believe, on the early afternoon of September 4th. And then not long after that, he hears that the defendant was shot on the side of the road. And so we've had some discussions about the drug issue. So before listening to that testimony, I alerted the defense and wanted to make sure that we had set our ground rules on that. And then, of course, the side of the road issue, which we've talked about earlier.
What ground rules did you set?
Your Honor sets the ground rules, and that's.
You take a break during questioning the witness to have a conference with counsel.
Well, I am seeking to admit that evidence, not only of what the defendant said about his drug use, but also to submit that not long after that, he heard about the side of the road incident. And I, out of abundance of caution, raised that issue, and I believe the defense was going to object, trying to give them the opportunity to do that in an in-camera setting.
All right.
Which, Your Honor, for both of those, I think they are admissible. As first of all, again, we're not offering any drug use, and we've had some discussion about that yesterday. We're not offering any drug use for the purposes of what's improper under 404. In this particular instance, the defendant himself identifies that as a reason for these alleged misdeeds. So not only is it not 404, it's just part of the res geste of his statement, which is part of what's been admitted.
It was admitted yesterday, so we're beyond that issue as far as the court is concerned.
All right. And then as far as the side of the road,
Particulars of which have not been disclosed, but the email from Mr. Murdaugh doing rehab was published by the defense.
yes, sir. And then secondly, along with the side of the road, again, at this point in time, just going to be admitted that he heard about what had happened to the defendant. There are other circumstances that we talked about earlier that, we would address at a later time about the side of the road, which we believe is admissible and admissible under 404. We could have, I don't know that we need to have an in-camera proceeding at this point in detail about that, but I just, because all he's going to say is he heard that happened. But I just wanted to, again, and out of abundance of caution, we've gone this far. I just wanted to be, before I listed anything along those lines, just wanted to alert the defense and give them a chance to object.
All right. Mr. Griffin?
Yeah, we do object, Your Honor. First, he's not the proper witness to be testifying about what happened on the side of the road. He just hears it secondhand, so any information he has is just hearsay. In the in-camera hearing, he also provided his opinion that Alec must have tried to commit suicide, and that's improper. So first is hearsay, but more importantly, Your Honor, it is a bridge too far under the narrow exception that you've offered, that they're offering this evidence of financial crimes, that is a motive for this alleged murder that he committed. And so the fact that whether it was an assisted suicide or they want to go further and say it's part of the same scheme and that it's a sympathy ploy, which the court hasn't ruled upon, and we don't think it meets the standard there, and it violates Rule 403. So for all those reasons, we object to it coming into evidence.
Do you want to proffer what Attorney Wilson is going to say about it?
I believe during his prior testimony in the in-camera hearing, and I certainly can do that, he testified.
Prior testimony.
Yes, sir.
Which did not involve anything about a roadside shooting.
Well, and so I'll go ahead and proffer, Your Honor. So, Mr. Wilson, kind of jumping ahead, you had a confrontation with the defendant on September 4th when you drove to Hampton County to have a meeting with him on the porch of Alameda. Is that correct?
Yes.
All right. And pull the mic forward to you a
Yes.
little bit. And without getting into all that detail, after that conversation, he made some admissions to you at that time. Is that correct?
Yes, sir.
And just very quickly tell the court what he said.
He admitted or said that he had had a drug problem for 20 plus years and that he was going to rehab. And then he said he admitted he had been stealing money.
And did he say anything about the 192 with you? Did he have a phrase he used for that?
Yes, sir.
What did he say?
You don't have to proffer this portion. You're indicating you're trying to go beyond this into something else.
What time did this, yes, sir, thank you, Your Honor. What time did this conversation take place roughly?
Late morning, just before lunch.
All right. And that's on September 4th?
Saturday, September 4th. Yes, sir.
After that confrontation, did you leave?
I did.
And where did you go?
I went through Hardee's in Hampton, grabbed a bite of lunch at the drive-through, and then drove back towards Columbia.
Did you hear about anything related to the defendant within a couple hours?
I did. I got a phone call from Lee Cope. Might have been Randy, but I think it was Lee Cope that called me and said Alec had been shot in the head and was being helicoptered. I thought he said to Savannah Hospital. I know he said to the hospital in a helicopter.
That's as far as this witness would go.
And I've sustained the objection as to this portion of the testimony. I agree with the defense's hearsay and And if it's, and he's not the appropriate witness to testify on this issue.
Thank you, Your Honor. So obviously, yeah, all right. And you're a lawyer, you understand where to stop.
Yes, sir.
All right.
We'll take a recess for about 10 minutes.
Briefly. You were asked by Mr. Griffin on June 7th whether or not you brought up anything about the Ferris fees, but at that point in time, you hadn't had to cover $192,000 for the defendant, had you?
No, sir, I had not.
And
It
as
it
far
was
as
July, the 15th, 16th, 17th, somewhere around in that range, middle of July, that I had to cover that $192,000.
that he called you with some story about how he had the money in the wrong structures and he needed to send it back to you, but he was 192 short.
Yes, sir. I'm sorry.
Don't lead the witness.
Did the defendant tell you that the issue of notifying his firm had been handled?
Yes, sir.
About the fees?
Before I wrote the checks in March and afterwards.
Before June the 7th, you were asked about that call with Lee Cope.
Yes,
And
sir.
did you talk about some fees and expenses that were still pending?
Not
Lee
with-
Cope?
Not with Lee Cope, no, sir.
What did you talk about with Lee Cope?
Lee asked me if all the money in the case, the Mack Trucks case, had been dispersed. And I told him that it hadn't. We were holding back some lien money, some medical bill money. And I was in Hampton, I believe, trying a case down there the whole week. And he approached me while I was working in and out of their office sometime. And I think that's when he approached me and spoke to me about it. And I told him I'd have to check. I wasn't in the office.
Did you tell Lee Cope at that time that you had already dispersed the fees and written them directly to Richard Alexander Murdaugh?
No, sir. He didn't ask me about the fees.
You were asked about the phone call that took place, or the phone calls, series of phone calls that you had with the defendant on the night of the murders, correct?
Yes, sir.
And he called you first, correct?
Yes, sir.
And then he sent you a text saying you up?
Yes, sir.
But in those phone calls, you were the one who raised the issue about the equipment issue, correct?
Yes, sir.
Were you the one who raised the issue about the equipment?
I did. I mean, I kept up with our deadlines and things that needed to be dealt with. And I want to say that the lawyer had reached out to me sometime around that time. I don't know whether they couldn't get Alec or just chose me to be the person to reach out to, but I was being contacted.
You were asked about him going to visit his mother in Alameda, typically during the day. And were you aware that he didn't go visit his father that day, despite the news that he had been put in the hospital?
I don't know. I don't think we talked about that night on those phone calls, whether he had gone to see his father or not. I asked how his father was, but I don't think he told me whether he had gone to see his father or not.
You were asked about your conversations that night with him, and I think you said he was acting like the normal Alex.
Yes, sir.
And you were asked about the fact of your observations of him as a husband,
Yes, sir.
as a father.
Yes, sir.
You said you saw no erratic behavior over the years that you've known him.
No, sir.
Saw no evidence of opioid use over the years that you've known him.
No, sir.
You said that he came from a prominent law firm,
Yes, sir.
prominent family,
Yes, sir.
that you respected him as a lawyer,
Yes, sir.
that his clients trusted him.
Yes, sir.
Object.
Sustain.
Was the defendant effective in closing argument?
Yes, sir. Very.
Did the defendant show emotion in closing argument?
I mean, yes, sir, he did.
Was the defendant good with people?
Very good with people. That's one of Alec's strengths, is with clients and people he met, connecting to people that he, didn't know quite as personally. He could make connections with people. He seemed to know what made people tick. He knew what was important to people. He could spot issues and address issues in a case. When you got him to focus, he could handle those things.
Did your kids grow up together?
They did.
Did you try cases with him?
We did.
You've done business with him over the years? Have you done business with him over the years?
Yes, sir. Lots.
Have you been roommates with him?
Yes, sir.
When you covered $192,000 for him, did you trust him and believe him when what he was telling you?
I believe that he would pay me back and that what he had told me had happened.
On September 4th,
and I knew I had to cover that money with my trust account. So yes, sir.
on September 4th, 2021, did he confess to you the truth of his life that those of whom were close to him, no one knew?
He confessed to me things about him that I didn't know.
And you had no idea about any of that.
No, sir.
And he said it had been going on for years.
He confessed to me things about him that I didn't know.
And you had no idea about any of that.
No, sir.
And he said it had been going on for years, the reality of his life.
He told me that he had been addicted to opioids, and I think he said either 420 or over 20 years.
And also,
And that he had been stealing money from his clients in the firm.
and that was a lightning bolt because you had no idea, despite being his best friend.
Objection leading, argument.
Were you one of his best friends?
Yes, sir.
Did you have any idea about any of that had been going on for a decade?
I had been told by Lee Coate the day before in that phone call that Alec had been stealing from his firm and from clients, and that he had a drug problem and was going into rehab. And that's the first I would have ever known that.
September 4th, 2021.
That was Friday, September the 3rd, when I talked to Lee Coate. And then again, when I talked to Alec on Saturday, September the 4th.
Hit you out of the blue.
Like a ton of bricks. I mean, it floored me when Lee called me. And I never expected that.
Thank you. Nothing further.
Further questions? You may step down.
Thank you.
We'll recess now for 1 hour and 15 minutes. Please go to the jury room. Please do not discuss the case. Anything before the jury comes in? Yes, sir.
Please, court, Your Honor, Mr. Waters has informed me that he is going to call a young man named Satterfield, who was one of the heirs of the Satterfield estate. Allegation is that Mr. Murdaugh converted those proceeds as like all the other conversions we've heard about. The difference is, in this case, he is the victim, and you know, Mr. Waters used the term gilding the lily the other day. He told us it meant piling on. Under the 403 analysis, and again, this is being allowed for the limited purpose of motive. We believe and would submit to the court that this is more prejudicial than it is probative. They've got records they put in of millions of dollars of theft, and you know, we would offer that if he has some summary chart, or we would, pursuant to our previous objections, stipulate to it as to the loss involved in this case, for purposes of what Your Honor's already allowed, with the obviously that stipulation be subject to our previous objections, rather than calling, you know, witnesses who are victims that add nothing to the evidence that Your Honor's allowed. And we would, under Rule 403, object to the prejudicial being more outweighed, the prejudicials outweighed by any probative value.
All right, yes, sir. Mr. Waters?
Your Honor, again, Mr. Satterfield testified in camera. There has already been testimony admitted again about him stealing through the fake forge from his clients, stealing from his law firm. But this is something different. This is where a situation where he was actually a civil defendant and still managed to misappropriate that money as well. And additionally, the amount of money is extremely significant. It's millions of dollars. And the other thing about this is that, as you heard from Mr. Satterfield, you know, the fact of this being out there was kind of percolating out in the world, and he had conversations with Mr. Murdaugh as time was approaching, and Mr. Murdaugh's telling him, oh, everything's okay with the case and all the rest of it, when the money had long been misappropriated and spent by Mr. Murdaugh. So this is a different type, and it also has a connection with the overriding situation that Mr. Murdaugh found himself in. And so we believe that it still is fair game, and is not is probative value is not substantially outweighed by the danger of any unfair prejudice.
What is the timeline with regard to Satterfield?
So Mr. Satterfield, as far as the communications with the defendant, the money, actually, the first settlement, I believe, was misappropriated not long after the boat case in March of 19, which is actually another aspect that's going on as well. There's been testimony about how the boat case changed things and created some very significant difficulties for the defendant that was coming to a head at that time. The subsequent recovery, which was much larger, of about $3.8 million, was at some point after that. However, there are, in fact, communications, and you heard from Mr. Satterfield, there are communications, text messages, which I provided to the defense in April of 2021, in which the defendant is assuring him that everything, they're working hard on the case and everything is fine and all the rest of it. And so that is, again, this is part and parcel of the things that are in these hidden aspects of this whole other life that the defendant had, that are percolating as everyone moves to June of 2021. Additionally, there are calls. I think Mr. Satterfield testified as to calls in June of 2021. The records reflect some calls on June 22nd between the two of them, but there still are text messages from the defendant. And Your Honor, I can have something marked at this time and pass it up if you'd like to see it. These actually were identified after he testified last time, but the defendant reaches out to him and tells him, hey, just checking on you. Everything's fine. We're working hard on the case. It's a tough case. It's a complex case. And therefore, you know, don't worry about it, when, again, the money had been long misappropriated.
Long answer, but not to the question. So what is the timeline? And perhaps the text messages have something to do with the timeline. I recalled his testimony, Satterfield's in-camera testimony, something to the effect that in early June or around that time,
Diverted in May of 2019.
yeah, the discovery is the discovery.
Did not come until
June 22nd, 2021.
right.
Satterfield testified that he heard reports at some point in time. That's my question to you, the
He
timeline.
testified that as we move into 2021, late 2021, he's hearing reports, and there are reports out there that there had been a settlement in the case. And so ultimately, there's discussions with Alec Murdaugh, which he'll testify he would, talk with a few times a year about the case, and was assured, even though, yes, Mr. Harpootlian's right, that money had been misappropriated a long time ago, that everything was okay. He was working hard on the case. And so that the fact of the important point to this case is that issue for the defendant is still out there. And he's got this young man, as we move into the spring of 2021, believing that the case is still ongoing and he's still working on it. And that's the connection here as part and parcel of the overwhelming set of circumstances for the defendant.
Your Honor, just briefly, money is misappropriated in 2019. That young man testified he didn't know when he learned about it may have been a settlement, could have been before June 7th or after June 7th. And the fact that he doesn't know when, I think, contributes to the fact that it caused for speculation that he knew something or that would have in some way would have influenced Alec Murdaugh to murder his wife and son. And that's what the only reason this testimony is coming in is to show there was some immediacy. And by the way, if you look at the phone records, the only calls between these folks began on June 22nd, 2 weeks after the murders. So it's not temporal, and he can't say whether he had any knowledge of the misappropriation of actually all he know about would be the settlement. That again, that there was nothing immediate about this on June 7th from this particular witness. Now, again, we'd be more than willing to some sort of stipulation that that's the timeline, subject to our previous objections, rather than putting a witness up who's going to testify. He doesn't know when he found out about it. Could have been before June 7th, could have been after. And they don't even begin phone calls about it till June 22nd. And there's nothing that no actions begun, nothing coming forward after or prior to June 22nd. And these emails all occur after June 7th. So again, this is a prejudicial versus probative. And this is gilding the lily. This is piling on. This is just more trying to prejudice the jury into believing that somehow someone who steals a bunch of money in any way whatsoever would commit a murder. This is character evidence, pure and simple.
Your Honor, the final misappropriation in the Satterfield case was in October of 2020. And again, there were press articles out there. The texts, he said these emails were after June 7th, and they're not. They're in April. Mr. Satterfield testified in camera that he remembered having a conversation in June of 2022. After that, we actually looked and we found some phone records, which again are June 22nd of 2021, but we also found these text messages from April in which the defendant is reaching out to Mr. Satterfield and assuring him that he's working hard on the case and all the rest of it. And again, that's part and parcel of the things that were percolating out there and part and parcel of the pressures that were on him that the state's theory is he could not solve.
Your Honor, just one last point. This all began with this idea, argued very thoroughly by the Attorney General, that all this financial crime stuff is to prove that on the night of June 7th, he knew, because of that conversation in the office, that the jig was up, that he, in a day or two, that hearing on Thursday, everyone would know that he was a thief and everything had crashed down on him. And to distract from that and delay things, he went home and butchered his son and butchered his wife. And by the way, I might point out, that same day he learned his father was terminal and wouldn't live much longer. And that would be, in my opinion, as much of, if not more, well, enough of a distraction
I agree.
for, you agree? That, that he didn't need, I mean, there's no rational way he would think he'd need to butcher his wife and son to distract, knowing his father's getting ready to die, which would be a distraction in that community, in that law firm. So again, I think we need to get back to why we began this 3 or 4 or 5, I can't remember how many days we've been doing financial. I mean, this is a murder trial, not a financial fraud trial. And to the extent it goes to motive, again, we're more than willing to stipulate that this amount of money disappeared, that the rightful heirs of it, receipt of it, didn't get it. But putting a child on the stand to talk about, and again, he didn't know when he found out about it, or when he began to raise those issues.
I believe he's an adult, isn't he?
He is an adult. He has a job in an emergency room as a tech.
I apologize to the young man. He looks young to me. I'm sorry.
Anything further?
Your Honor, the only thing I would say is that the state's theory isn't as simple as that. It's broader than that. But again, I think that this is a different category, and it's part and parcel of everything that was going on as we moved to June 7th, and therefore is relevant for the jury to understand very much as the pressures that could cause him to murder his wife and son, particularly in the face of the defense contention that he could never do such a thing.
Satterfield testified in camera that in June of 2021, he made a call to Mr. Murdaugh asking about the status of the case. He made that call, he testified to, because he had heard reports that that there was some concern about the status of the case sufficient to call him to cause him to call Mr. Murdaugh to ask about the status of it. And he testified that he could not remember if he called Mr. Murdaugh or if Mr. Murdaugh called him. But yes, I talked to him in June of 2021. That's according to the rough draft of the transcript that has been provided to the court. I find that this testimony is consistent with the state's theory of of the defendant being in a frantic state, seeking to avoid disclosure of these financial crimes and thefts, and that this testimony is consistent with the state's theory. The court has granted the state's motion to allow evidence of other crimes, and this is additional evidence that that is close in point in time and is admissible, and I deny the motion to exclude it. Yes, sir.
Bring to your attention one factual issue. The Attorney General has.
Of course, I asked, is there anything else? But go ahead.
I apologize, Your Honor. I'm trying to hurry if I can because there may be an ending to this case someday, but I'm not trying to delay it. The phone records the Attorney General is going to present through this witness indicate the only calls between the two of them were on June 22nd, 2 weeks after the murder. So if there's some phone call, there's no mystery about when the phone call came. After June 7th, 2 weeks later. So in terms of him putting Mr. Murdaugh on alert that something imminent was going to happen, it's 2 weeks later.
Well, it's impossible for anyone to know what's on one's mind or state of mind at any given point in time. But the magnitude of this case almost morphs all the others in the amount, and it is something that I would, if one is being concerned and attempting to prevent disclosure and seeking to divert attention from the impending disclosure of information, and that disclosure would likely have taken place not only for some of the others that we've had testimony concerning, but most definitely this particular one. So I understand your objection. That's a fact and issue, but I find that it's more probative than prejudicial for all of the reasons I previously explained. Yes, sir.
So,
And I don't think whether it's June 1st, 2nd, 3rd, 20th, 21st, 25th, I don't think it's of any significant difference.
well, Your Honor, as you said just a moment ago, and if you charge a jury with this, maybe I'll sit down, which is no one knows what's going on in somebody's mind. And maybe that's something you can tell the jury at the end of this case. Secondly, since this is
Specific charge on that intent. Right.
moving on, we would ask two things. One, I would accept your ruling. I'm not sure I have to do that, but I'm from the old school. If you didn't preserve it,
Yes, sir.
it was gone. Secondly, we would ask you to, and I know you said yesterday you weren't going to do this again, but this is, as he's just pointed out, a horse of a different color. It's a different character, kind of witness. I would ask you to read your charge on this testimony once again. And hopefully, I think that we're close to the end of this financial testimony, so it may be the last time I would request you to read it.
Yes, sir.
Thank you.
Yes, sir.
Obviously, leave that to the court's discretion.
Yes, sir. I have it right here. I will
Thank you.
give it one more time. Let's bring the jury. Sir, thank you. Welcome back once again. Ladies and gentlemen, the state's next witness is expected to give testimony, further testimony regarding other crimes committed by the defendant, other alleged criminal activity by the defendant. And as I instructed you earlier, the fact that the defendant may or may not have been involved in other criminal activity is not evidence of or proof that he committed the offenses alleged in the indictments against him. This testimony is allowed for the limited purpose of assisting the state in proving the state's theory or allegations regarding motive, and you may not consider it for purposes of Mr. Murdaugh's character, or you cannot consider that as for propensity to commit other crimes, or that it's more likely that he committed these other crimes which he's been charged but not convicted of. but it is being allowed based on the state's theory and representations that it helps explain the defendant's motive to commit the crimes for which he is accused. And you may call your next witness.
May it please the court, Your Honor, the state calls Tony Satterfield.
Left hand on the Bible. Do you affirm the testimony about to give the court shall be the truth, so help you God? State your name again for the record. Spell your last name after you sit down. And pull your chair up so we can hear you, okay?
My name is Michael Satterfield. My last name is spelled Satterfield.
Mr. Satterfield, how you doing today?
Good, how are you?
I'm good. Tell the jury just a little bit about yourself. Where'd you grow up, and what do you do for a living?
I grew up in Hampton, live in Beaufort, and I work at Beaufort Memorial Hospital.
Awesome. And court reporter's taking stuff down there. I'm really known for talking fast too, but let's slow it down so they can get everything down. You grew up in Hampton, you said,
Yes,
and you said where'd you work?
Beaufort Memorial,
Okay. And what do you do there?
work in the ER.
How long have you been working there?
A little over 5 years.
Okay. And where did you work anywhere prior to that?
I did.
And where'd you work?
The pharmacy.
Pharmacy. Who's your mom?
Gloria Satterfield.
Gloria Satterfield. And is your mom still with us?
She's not.
And when did she pass?
February 26, 2018.
And do you have a sibling?
I do.
And what's his name?
Brian,
Where'd your mom pass?
in the hospital.
Did something happen to her?
Yes.
Tell the jury what happened to her.
She had a trip and fall.
And where did that occur?
I'm not sure the exact date that occurred.
But where?
I'm sorry, at Moselle in Colleton County.
Okay. Was she working for the Murdaugh family?
She was.
And what did she do for them?
She was their housekeeper, babysat for them and anything else they needed.
Babysat, whatever they needed?
Yes.
Housekeeper? How long did she work for them?
A little over 20 years. I'm not sure the exact amount.
20 years. During that time, did you get to know the Murdaugh family?
I did.
Did you get to know the defendant, Alec Murdaugh?
I did.
Do you see him here in the courtroom today?
I do.
Can you point him out to the jury, for the jury? Can the record reflect he's identified the defendant? Your mom worked for this family for 20 years, babysitting. She helped raise the children.
Yes.
Did you get to know Maggie?
A little bit, yes.
Did you get to know Paul or Buster at all?
A little bit, yes.
And you got to know Alec? Right?
Yes.
You said your mom had a trip and fall at Moselle at their property,
Yes.
and she go to the hospital.
Yes.
Was she ever able to tell you how she tripped or anything like that?
No.
How long was she in the hospital before she passed away?
Give and take 4, 5 weeks, somewhere up in there.
After she passed away, did you, was there a funeral?
Yes.
And after the funeral, did people go to somebody's house and visit like people do?
Yes.
At any point in time during that funeral or thereabouts, did you have a conversation with the defendant? over there?
Yes.
And what,
Objecting to questions by Mr. Water that respond with a yes or no. Those are typically leading questions. Not that I'm concerned about these questions. I just don't want my lack of objection to lead to somebody's belief that he can ask questions that respond with a yes or a no. Thank
Mr.
you.
Waters?
I think my question did not suggest the answer. It said, did you have a conversation? And my next question was, what was that conversation? So what was that question, what was that conversation you had with the defendant at the funeral or thereabouts?
If I remember correctly, I'm gonna kind of take care of you boys and kind of, you know,
He's going to do what? I'm sorry?
take care of you boys.
Did he say how he was going to do that?
Partially, yes.
And what did he say?
He was gonna file a claim against his insurance company.
He's going to what?
File a claim against his insurance company.
His insurance company?
Yes.
Did he say how much coverage there was?
Like 505,000, I believe.
505,000?
Yes.
And did he say anything about how much money you may receive?
The goal was to get me and my brother Brian at least $100,000 apiece.
And did any other bills need to be taken care of?
The medical bills.
For who?
My mom.
When he told you that, did you agree to do that?
Yes.
Did you view the defendant as your lawyer?
Yes.
Did you go and meet with him about it?
Yes.
Did he tell you about what to do with any paperwork you may receive?
Any paperwork or bills or anything, just send them to him.
Have the Elmo, please.
No objection subject to our previously made objection.
All right. Is that something you're offering into evidence?
I'm going to show it to the witness, but yes, sir. Yeah, I'll offer states 372 in evidence. Yes, sir.
Submitted without objection.
Let me ask you this. So did you agree to let the defendant go forward with this claim?
Yes.
And I'd asked you whether or not what he told you to do about paperwork, and I'm going to show you what's been marked as Exhibit 372 to your testimony. Do you recognize that?
Yes.
Tell the jury what that is, please.
This is a cover sheet that I sent him with, I believe behind it was like a hospital bill and some kind of other important paperwork.
Okay. So you had received some paperwork in the mail?
Yes,
And did you handwrite this?
I did.
All right. And who'd you send this to?
Alex Murdaugh.
Put it up on the screen. And tell the jury quickly what this is about. Can you see it on the screen? I can bring it back to you if you need.
Okay. So this is a cover sheet that I attached to the documents that I sent Alex.
And what kind of documents? Do you remember what kind they were?
One was a hospital bill and one was from the trailer company, I believe. I don't recall exactly what it was.
The trailer company for who?
My mom.
For your mom. And the hospital bill for who?
Yes, my mom.
Your mom. And you sent these to him because they were relevant to the case?
Yes.
At any point in time, did you, as this case was developing, did you go and meet with the defendant at his office?
Yes.
Did he have any paperwork for you?
Yes.
Did he get you to sign some paperwork?
Yes.
Did you become the personal representative of your mom's estate?
I did.
And who gave you the paperwork to sign for that?
Alex.
When you signed that paperwork, were you aware that there had already been a?
Leading.
Can't leave the witness.
At some point in time, did Alex say he wanted to involve another lawyer?
Yes.
And who was that?
Corey Fleming.
And what did he tell you about that?
If I understood it correctly, I'm gonna send you to Corey Fleming, my friend, because I can't do it against, do the claim against myself because it'd be a conflict of interest. That's how I understood it.
And did you ultimately meet with Corey Fleming?
Yes.
How many times did you meet with him?
If I recall correctly, maybe once or twice.
Over the course of this case, if you had a question, who would you call?
Alex.
At some point, did the defendant, Alec, have a conversation with you about letting someone else be PR?
Yes.
And what was that conversation?
That I should let somebody else be PR because based on he's a businessman and it would be hard for the insurance to go up against somebody like that.
Okay. And who told you that?
Alex?
And what did you say to that?
Yes.
And did somebody else get involved at this point?
Yes.
And who was that?
The PR, Chad Westendorf.
At that point in time, did you sign any paperwork for him to become PR?
I
Chad?
did.
And who brought you that paperwork?
I believe I signed it at Alex's office or either I went to the bank. I can't recall.
And at that point in time, were you aware of any recovery in the case?
No.
Were you aware a recovery had already been received in the case?
No.
Did anyone at that time tell you there was already $505,000 that had been recovered?
No.
That's not in evidence. I mean, he's just throwing these numbers and times out. There's nothing in the record to indicate when it was received or how it was dispersed. I object.
I asked him, Your Honor, I'm sorry. I asked him if he was aware of that. I think that's relevant.
Aware of something that no one's said happened? I mean, I would object.
You rephrase your question, please.
Did Alec tell you there had been a recovery of $505,000 already in the case at that time?
No.
Did he ever tell you there had been a recovery of $505,000 at that time?
No.
Was there a recovery at that time of $505,000 as you come to find out?
Later on.
Later on you found out?
Yes.
And did he ever pay you one dime?
No.
Who was the PR that the defendant talked to you about appointing instead of you?
Chad Westendorf.
Did you ever meet with him?
Yes, like once or twice.
Did he ever tell you about a $505,000 settlement that already had occurred?
No.
Did the defendant ever tell you that he also had a $5 million umbrella policy?
No.
Did he ever tell you that there had been a recovery against that?
No.
Did he ever tell you that there had been a recovery for $3.8 million against that?
No.
Did he ever pay you one penny of $3.8 million?
No.
As the months went on and moving into the early part of June 2021, would you periodically have conversations with Alec about the case?
Yes.
How often do you think he would talk to Alec?
Every 3 to 4 months, give and take.
And you recall what Alec would tell you about the case?
Yes. First it started off, the hard case, and then it was making progress.
Say that again.
At first it started off as it was going to be a hard case, and then it turned into we're making progress.
You're making progress?
Yes.
And what had the defendant told you about the most that you could recover? What did he tell you at least?
Nothing.
I'm going to show you what's been marked as State's Exhibit 463 to your testimony and see if you recognize that document.
Yes, I do.
And what are those?
These are text messages between me and Alex.
Your Honor, at this time I would move State's 463 and that 453, excuse me, into evidence.
Subject to previous objections, no objection.
Okay, it's admitted.
All right, I'm going to put this up on the screen and kind of zoom it in. You got a screen over there, but if you can't see it because the writing's kind of small, you let me know and I'll bring it to you, okay? Do you recognize that's on the screen right now?
Yes.
And who is that text from?
Alex.
And who is it to?
Me.
And can you read to the jury what that text says?
It says, "Hey man, just checking in, been working on case and made me think about you. Hope all is good. Call me anytime I can help."
And what was the date of that text?
April 12th, 2021 at 12:47.
All right. I'm gonna go to this next one. Do you recognize that text?
Yes.
And who is that from?
That is from me to Alex responding to his text.
All right. And read that text to the jury once you sent.
That text says, "Hey man, I'm doing good. By the way, how's the case going? Just curious, but how are you?"
I'll show you this next text. Do you recognize that?
Yes.
And who is that from?
That is from Alex to me.
All right. And can you read that to the jury?
Finally getting some movement, still a ways to go, doing good, was just thinking about and thought I'd check in. Hope to see you soon.
Still a ways to go is what he said?
Yes.
At that point in time, did he tell you there had already been 2 recoveries in the case?
No.
Going to this last text, what is that? Who is that from?
That is from me back to Alex responding to his text.
All right. And what does it say?
Cool, thanks.
Hold on for me just one second. I believe without objection, I'm going to strike out one of the phone numbers on here so it can't be viewed. That's correct. Around this point in time, so we're in the late spring of 2021. Had you become aware of any media reporting about there actually being a settlement in your mother's case?
Yes, somebody sent me a text or something saying a legal document, but I can't remember who sent it to me.
All right. And you can't remember who sent it to you?
Yes, that's correct.
Did that cause you to reach out to the defendant and ask the status of the case?
Yes.
Do you remember roughly when that was?
I believe in June.
And do you remember if that was before or after the murders in this particular case?
I believe that was after.
Okay. And have you seen some records since the previous time in talking about this?
Previous to the call, no.
Let me show you what's been marked as 454 to your testimony. Is that some records you've been provided?
Yes.
And there's just some records of phone calls between you and Alec
Yes.
on June 22nd?
Yes.
Did you have any, would you periodically reach out to the defendant and get updates about the case?
Yes.
And you had family reach out and ask you to get updates because of reading things in the media, is that correct?
That is correct.
And you had conversations with him in June of 2021?
Yes.
You don't remember if those were before or after the murders?
Answered the question after June 7th. I would object to the leading question. I would object to the suggestion that he hasn't already answered that this occurred after June 7th, 2021. He's impeaching his own witness.
I think I'm establishing a point that's not in dispute. These records say what they say.
I'm talking, I think he was prefacing that question with, you don't remember when you learned about it sometime in early June. If he conceding, the witness said he didn't learn about it until after June 7th, we don't have an argument. He's already testified to that.
Final speaking response.
Your Honor, this witness has testified he had a conversation in June. He's testified in the spring of 2021 that he became aware of media reports and reached out to him. We've already seen some texts and we have some calls. I'm just following up on the fact that he had repeated communications with the defendant, asking him what is the status of my case, and was told as we move in time to the murders, oh, everything's fine, I'm still working on it.
Sustained as to leading the witness.
For thanking you. It's just a habit I got in and I can't seem to break it. I apologize. And by the way, if you ruled against me, I would still say thank you. It's just what I've learned to do. I don't know whether it's an old time thing or not. But I apologize.
Thank you, Mr. Harper. Just to clear this up, how often would you talk to the defendant?
3 to 4 times a year or something, I believe. I can't recall. Every few months.
Would you talk by phone or would you talk by text or both?
Both.
And when you would talk to him, would you ask about the status of your case?
Yes.
And each time you talked to him, what did he say?
It was making progress.
Making progress. Did he say it was a hard case or not?
Yes.
Did he ever tell you about how much money he might be able to get for you?
The goal was to get 100,000 apiece for me and my brother.
At any time over the years, did he ever tell you that there had already been a recovery in the case?
No.
At any time over the years, did he mention anything about having a $5 million umbrella policy?
No.
At any time, did he ever pay you 1 penny?
No.
You testified earlier that you became the personal representative. Is that right?
That is correct.
Why were you the personal representative and not your brother?
Because my brother is a vulnerable adult man and he has a disability. That my brother, he's a vulnerable adult, so he's not able to function as a normal human being to be doing stuff like that.
He's a vulnerable adult.
Yes.
After the murders happened, at some point after that, did you go seek, or did you and your family go seek additional representation about this matter?
Yes.
And who did y'all eventually go to?
My aunt and my uncle went to Mark Tinsley, and then they sent us to Eric Bland.
And are you aware of there being a confession of judgment in your case against the defendant for those missing recoveries?
Yes.
This document.
Sir.
Your Honor, I'm offer states 352. And you're aware there's a confession of judgment in that case?
Yes.
Did you have to file a claim against the defendant for those 2 recoveries you never got for your mom's case?
Yes.
And I'm going to show you 352. You're not a lawyer, are you?
No.
And have you read all that legal stuff in there?
Yes.
All right. But this has been something that you're aware of that occurred in your case. Is that correct?
That is correct.
And ultimately, there's a confession of judgment in the case. Do you know how much it is right there?
$4,305,000.
And is that for $3.8 million for one of them?
Yes.
And for $505,000 for the other recovery?
Yes.
Exhibit is admitted.
Thank you, Your Honor. Oops, I just did it. When the defendant came to you around the time of your mom's funeral and said he was going to help you and file a claim on your behalf, why did you agree to that?
Because I trusted him.
Thank you. Nothing further.
Examination.
Please report, Your Honor.
Yes.
Your name is Tony.
Yes, sir.
May I call you Tony rather than Mr. Satterfield?
Absolutely.
You can call me Dick instead of Mr. Harpizian, and then we'll make this a little quicker. Between your name and my name, it might add a little bit to this clause. So let me ask you a few questions about your mother's death, and I apologize if in any way this brings back bad memories. I apologize. Y'all filed a lawsuit or made a claim against, I mean, basically Alec told you he would be the defendant. You'd be suing him, right?
Yes.
Okay. And it was based on some dogs tripping your mom as she was going down the stairs. Is that right?
That's what they said, yes.
Okay. But the only person that represented dogs tripped your mother going down the stairs was Alex, right?
Yes.
Okay. So without his assertion, I mean, if she just fell down the stairs, there'd be no lawsuit, right?
I guess that's correct.
Okay, I'm sorry, you're not a lawyer. You would accept my representations if she just fell down the stairs on her own. There would be no one to blame for that. Right?
All right. Repeat the question because I don't understand the question.
It's okay. Strike it, withdraw it. It's going down a rabbit hole. Don't need to do that. So let me ask you this. During this process, your lawyer, for the record, he told you, was Corey Fleming, right?
Yes.
And that was your lawyer.
Well, that was Murdaugh. They were all a team.
They
Both
were
a
a team. The person being sued, and
Yeah.
again, you're not sophisticated on this, was part of the team to get you a recovery.
Yes.
Okay. Now, there's a guy named Chad Westendorf. He was with a bank, right?
Yes.
And he was actually the PR. He took over, and it was his job to make sure y'all got your money, right?
Yes.
Did you ever meet with him?
Yes.
And what did he say?
Like one time, it was just to sign some paperwork for him to be PR.
Right? And did you ever call him and say, what's going on with my case?
No.
Did you ever call Corey Fleming and ask what's going on with my case?
No.
And let me make sure I understand your testimony. You got some notice of something in the paper, and at some point after June 7th, you had either a phone call or a text or an email with Alec Murdaugh asking him what's going on, right?
Yes.
Now, and again, we see a series of phone calls on June 22nd.
Yes.
Is that
Yes.
right? Where y'all were talking about this.
Yes.
But was there anything on June 7th or prior to June 7th where you accused him of anything?
Prior to June 7th? No.
Okay. Now, after you became aware of well, we saw just a moment ago a confession of judgment where Alec Murdaugh admitted that he owed you $3 million. Not get this wrong. Where's the confession of judgment? There it is. $4,305,000. Is that right?
That's the judgment, yes.
Okay. But you hired a lawyer, Eric Bland, very fine lawyer, and he actually sued Mr. Murdaugh's firm and some other folks and got you $6.5 million, right?
Yes. Or no, not that I'm aware of.
Pardon me?
Not that I'm aware of. The only thing I'm aware of is the judgment.
So Mr. Bland didn't tell you about the 6.5 million?
Yes.
Okay, I'm sorry. I just want to make sure he's not repeating himself here. And so you actually recovered 6.5 million, which would be a couple $1 million more than you would have gotten had you received the money that Alex took, right?
Yes.
Okay. So you've been made more than whole for that loss.
Yes.
2 million more than you would have gotten had he not taken your money, right?
Okay, yes.
Okay. Now, sort of the last question that I think I have for you, but let me check with my co-counsel. Well, one last question is this. On June 7th, prior to June 8th, had you ever threatened Alec Murdaugh with exposure?
All right, could you repeat the question again?
Prior to June 8th, 2021, did you ever threaten Alec Murdaugh saying, I know you stole my money. Where's my money? You know, I know you've got the money. Did you threaten him in any way?
No.
Okay. Thank you. I have no further questions.
Thank you. Going back to, excuse me, get the right exhibit. States 453. These were texts that you had about the case, is that right?
Yes.
And when did those occur?
These occurred in the spring and April of 2021.
April of 2021? And there had been media reporting about there being a settlement in this particular case, even though you hadn't received any money?
Yes.
Did you have periodic conversations with the defendant over the course of time?
Yes.
And would you ask him about the case?
Yes.
And he would tell you what?
It's a hard case, but it's a work in progress.
After all this happened, have you come to find out that the defendant took all of your money?
Yes.
And that's what led to that confession of judgment?
Yes.
Did he, though, ever pay you 1 cent?
No.
You were asked about Corey Fleming, and I think you said they were all a team. Is that
Yes.
right?
Yes.
At its core, who did you consider was your lawyer for your mom's case?
Alex.
Thank you, Mr. Satterfield. Nothing further. He may have one more question.
Anything further?
No. Thank you.
All right, you may step down. Thank you. We call your next witness.
The state calls Jan Malinowski.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Take a seat in the witness stand, please.
Thank you.
State your name again for the record. Spell your last name.
My name's Jan Malinowski, Malinowski.
Mr. Malinowski, how are you doing today?
Doing well, thank you.
Good. Introduce yourself to the jury a little bit. Just tell them a little bit about yourself, kind of a little bit about your background and your career, and ultimately where you are now.
I am currently the CEO of Palmetto State Bank, headquartered in Hampton. I work in the Beaufort office. Started banking career out of the Citadel in the late 70s. Went to graduate school at the University of South Carolina. Had a progression of jobs at larger banks, Wachovia Bank and Trust, Barnett Banks of Florida, First Union Bank, and then in February of 1991, I joined Palmetto State Bank.
Okay. And Palmetto State Bank, so you've been there since 1991?
Yes, sir.
And what roles have you served at Palmetto State Bank over the years?
Principally in charge of both of our branches. We have two branches in the Beaufort area, one on Ladies Island and one in the Burton, which is west of Beaufort. And that's been primarily my focus on a day-to-day basis, but I do have other responsibilities inside the company.
Okay. And your primary focus has been on Beaufort. Over here recently, has your duties or your role expanded?
It has.
And what is your current duty right now, or what your
I'm
current
the Chief
title?
Executive Officer,
The CEO. Okay. And when did you become the CEO of Palmetto State Bank?
April of last year.
April of last year?
Yes.
Would that be 2022?
Excuse me, I mean, August of last year.
August of last year. 2022.
Yes, sir.
Who was the CEO prior to that?
Russell Lafitte?
We'll talk more about that in a bit. Tell me a little bit more about the governance of the bank. Is there a board of directors?
There is
And how many people are on the board of directors?
currently 8.
And is there a executive committee of board of directors and other senior leadership at the bank?
There is.
And can you describe that for the jury, please?
The executive committee today consists of our chairman, Becky Lafitte, Norris Lafitte, Liz Malinowski. I'm on the executive committee, and Gray Henderson is on the executive committee.
All right, but describe to me how that works. What's the purpose of the executive committee?
Executive committee is charged with typically making the senior decisions, management, upper management decisions that affect the day-to-day operations of the bank.
And let me ask you this, as far as giving loans, are there levels of authority for different officials in the bank? And does that sort of graduate depending on the amount?
That's correct.
Can you explain that to the jury?
Throughout the bank, we have a number of loan officers, each of whom is granted a certain level of lending authority, which is approved annually by the board of directors. Any loans made, single loans above their lending authority or above their limits would then go to 2 executive officers, either myself or Ms. Henderson, to be approved or denied within our level of authority, which is up to $1 million. And then if for any loan, single loan or relationship from $1 million to $1.5 million, both she and I would have the approval authority, and anything above $1.5 million up to $8 million currently goes to the executive committee for approval.
With those levels of authority, still, if you have large loans with a particular customer or typical client, are those the kind of things that might be discussed and updated in board meetings and executive committee meetings?
Executive committee meetings first, and those would be minuted in the executive committee minutes, and then elevated to the board, and periodically there'd be board discussions, yes.
Let's talk a little bit and going back to September 2021 and before. And just want to talk a little bit about the bank then. Your primary focus in the bank was where at that period of time?
Beaufort.
All right. And was there another sort of hub of focus in the institution?
Well, Hampton is our main office.
Okay.
It's the largest branch among the 7 branches.
Back in that period of time, September 2021 and prior, explain to me how those 2 hubs work and just generally how the bank operated in practice in that regard.
Well, Hampton being the largest office had the most business. It was also a location where Russell Lafitte had his office, his father Charlie had his office, and Sister Gray Henderson had her office. Largely, I was focused on the activities in Beaufort, as I said earlier.
Did the bank have kind of a decentralized functioning that Hampton kind of did its thing and Beaufort did its thing to some extent?
Yes, sir, to some extent.
And was the defendant a customer of the bank?
Yes, he was.
And was he more in the Hampton side of things or the Beaufort side of things?
Hampton.
Did the defendant have a particular banking relationship with one particular official at the bank or former official?
Yes, Russell
was-
Lafitte.
Russell Lafitte? Moving into 2021, spring of 2021, or just during 2021, did you, as primarily the Beaufort side, but as also as a board member, did you have any particular concern at that time about the defendant, Alec Murdaugh's the nature of his relationship with the bank?
At that time, no,
Didn't have any concern at that time?
no, sir.
You were more focused on Buford, is that right?
Correct.
And you had no reason at that time to think that anything was going on, is that correct?
No, sir.
At some point in time, did you become aware, obviously, of the murders of Maggie and Paul Murdaugh?
Yes, sir.
After that happened, did you have any particular concern about the defendant and any loans he owed to the bank or anything about like that? at the time?
He had significant loans with the bank. The murders were obviously traumatic and tragic. And the board and executive committee did bring up Mr. Murdaugh's relationship with the bank.
Grab some exhibits real quick. We'll show you what's been marked as Exhibit 355 to your testimony. Let me show it to defense counsel real quick. We'll see if you recognize this document.
It's the minutes of a board of directors meeting of Palmetto State Bank, Tuesday, July 20th, 2021.
All right. And who was the secretary for those minutes?
Ray Henderson.
All right. And just quickly tell the jury what minutes of a board of directors meeting are. What do those mean?
The minutes should memorialize the discussions of the board members across any number of topics, loans, operations of the bank, any other topics of interest.
Okay. And just look at that real quick. That's on what date?
It's the meeting of July 20, 2021.
July 20, 2021. And I looked through there real quick, and was there any discussion or any mention of any discussion of any loans with the defendant, Alec Murdaugh?
No, sir, there are not.
Okay. Your Honor, at this time I would move, I believe without any additional objections, state 355 into evidence.
No other objections.
It's admitted.
Moving on from July, I just want to be clear. Were you aware in July of 2021 of any additional loan being made to Alec Murdaugh?
No, I was not.
Moving on into August 2021, did you at some point become aware, or was there some event occurring at the bank where any loans to Alec Murdaugh came to the board of directors' attention?
Yes, on August 9th.
Go ahead, describe that to the jury.
On August 9th, our board member, Norris Lafitte, emailed the board and the executive committee asking for a complete accounting of Alec Murdaugh's loan relationship with Palmetto State Bank.
All right, and did any events start to happen as a result of that?
Yes, there were.
All right, let's take them in order and let's go nice and slow so I can follow along. Dude, what was the first thing that happened?
A deposit of $400,000 was made to one of Mr. Murdaugh's account.
A deposit of $400,000. Who caused that deposit to be made?
Russell Lafitte.
At that time, on August 9th, do you know what the balance was in that particular account that money was in?
It was overdrawn significantly, I believe, above $367,000.
All right, and I'm going to hold on for me real quick. All right, thank you, Judge. State 356, I'm gonna show you this document, see if you recognize this.
This is a copy of an account statement, page 2 of an account statement of account number ending in the 4 digits 6092 of Richard Alexander Murdaugh.
All right, and can you tell me on August 6th, 2021, what the balance was in the defendant's account for Palmetto State Bank?
On August 6, 2021, the balance was a negative $347,784.67.
Had the bank continued paying expenses for Alec Murdaugh from June 7th to this date to the tune of $347,000 in money he did not have?
Correct.
Your Honor, this time I'd move State 356 into evidence.
No additional objections. Your Honor.
It's admitted.
So right here, what date is that?
August 6, 2021,
Go up to the top. What's the name on this account?
Richard Alexander Murdaugh.
And what's the balance in his account again, please?
A negative $347,784.67.
What is that right there?
Overdraft charge,
How much is the overdraft charge?
$5.
$5. Is that typical policy for a bank to pay overdrafts over the course of a month for $347,000?
No, sir,
And were you aware of that at the time?
I was not.
What is this right here? This transaction, what's the date on it?
August 9th, 2021.
And what is that right there?
That's a deposit of $400,000.
Okay. And is that what you were describing was the first action as a result of one of the board members inquiring about the status of Richard Alexander Murdaugh's accounts with the bank?
Yes, sir.
And who caused that deposit to be made?
Russell Lafitte.
And what was the source of those funds of $400,000?
It was a debit to an account or general ledger account called loans not on system.
What does that mean? Where's that money coming from? Did that belong to any entity? Where did it come from?
It came from the bank.
From the bank. At that period in time, was there any loan application in existence or any sort of paperwork to justify that $400,000?
No.
And after that $400,000 went on in, what was the balance of the account?
Had a positive balance of $52,215.33.
A little walking around money. When that deposit went in, were you aware of a deposit of $400,000 going in at that time?
At that time, no.
And you're a board member, correct?
Yes, sir.
All right, that was the first action. What else occurred, if anything, as a result of an inquiry being made about the defendant's finances?
There was flurry of activity inside the Hampton office to create loan documents.
To create loan documents?
Yes, sir.
Create loan documents after the fact?
Yes, sir.
What, if anything else, happened after that as a result of that inquiry?
As a result of that inquiry, a memo was drafted and submitted to the executive committee outlining the relationship of Alec Murdaugh at that time.
Hold on 1 second. I'll try to knock out two at once. so those three actions take place. At some point, does this finally come to your attention and to the rest of the board's attention?
It does.
And you recall about what date that was?
I believe it would have been the date of the executive committee on the 12th.
All right. And I'm going to show you what's been marked as State's Exhibit 354 to your testimony and see if you recognize that.
These are minutes of the executive committee that took place August 12th, 2021.
All right. And then reviewing those, do they generally accurately reflect what y'all talked about at that executive committee meeting?
Yes, sir.
And is there any reference or discussion of the defendant, Richard Alexander Murdaugh?
There is.
All right. And again, was this the first time that you were aware of the true nature of his financial condition and the fact of any further monies being expended to him from the bank?
This was, again, the formal summary of his banking relationship at that time. Yes.
Your Honor, this time I'd offer State's 356 in evidence. 354, my apologies.
It's 354, correct?
354.
And no additional objection.
Submitted.
All right. And the first sentence is, what does that say right there?
Says Gray Henderson distributed a memo to the members outlining the bank's current relationship.
Okay. And what's the second sentence right there?
Indebtedness totals $4.2 million, consisting of various unsecured and secured notes, a co-borrowing, and guaranteed loans.
So he owes the bank how much at that point in time?
At that time, $4.2 million.
You also got that too, correct?
Yes, sir.
We'll show you what's been marked as 365 to your testimony or to this trial and see if you recognize that.
This is a copy of the memo that was presented to the executive committee on the 12th of August.
All right. And Your Honor, this time I'd offer State's 365 in evidence.
No additional objection, Your Honor.
Submitted.
And this is that memo you were talking about that was prepared?
Yes, sir.
All right. And does this kind of set forth some of the debts and obligations that were owed by the defendant at that point in time?
It does.
All right. And in that second sentence, what is that total amount?
He currently has total principal balance through family, et cetera, $4,219,623.
This list right here, what does that reflect?
It lists all the loan numbers, the principal balances, and the collateral if they were secured.
Now, you mentioned we've talked about the memo, we've talked about the transfer, and you mentioned that there was some application documentation that started to be created. Is that correct?
Yes, sir.
All right. And you're the CEO now, is that correct?
That's correct.
And you've had a chance to go back and to look into what's happened and review these various records. Is that right?
Yes, sir.
We'll show you what's been marked as Exhibit 362 to your testimony and see if you recognize this document.
This is a copy of a Palmetto State Bank promissory note, commercial, single advance, loan number 6996048, in the amount of $750,750.
And who's the borrower on that particular document?
Richard Alexander Murdaugh.
All right. And then I'm going to show you what's been marked as 363 and see if you recognize that.
This is a document that accompanies the note. It's part of the loan package. It's called a business purpose statement.
Your Honor, this time I'd move in States 362 and 363.
No additional objection, Your Honor.
Submitted.
All right, let's take a look at this document real quick. This is 362. Looking at the last page, what date is that document signed?
July 15th, 2021.
All right. Going back and looking at the first page, could this document that was at least supposedly signed on July 15th, 2021, could it have even existed on July 15th, 2021?
No, sir,
It could not have.
it could not have.
And tell the jury why you know that.
Because the loan numbers generated by one of our software programs related to loan transactions, the loan numbers are issued sequentially.
All right. And so this sequential number
This
would have,
was- This was not a July sequence number.
all right. And so what month would it have been a sequence?
August.
And is that how you know that this didn't occur until August after
Yes.
that inquiry was made?
Yes, sir.
Well, let's talk about July 15th, 2021. As things have come to light and you look more into this, did it come to your attention as to why these documents would have been backdated to July of 2021?
Yes, sir, because there was another subsequent transaction.
All right. And what transaction was that generally?
It was a wire transfer.
Okay. We'll show you what's been marked as states 358 to your testimony, see if you recognize that.
This is our standard domestic wire request form dated July 15th, 2021.
Okay. And Your Honor, this time I would move to admit states 358. Objection.
Admit it.
Did you know about this wire when it was sent?
No, sir.
Did you know about this wire in August of 2021?
I did upon subsequent investigation, yes,
And when did you find out about that, roughly?
in August of 2021.
Put this up on the screen. What's the date on this wire?
July 15th, 2021.
And where does this wire go?
It goes to the Wilson Law Group LLC IOLTA account.
IOLTA account? Are you familiar if that's a lawyer trust account?
Yes, sir.
And what's this page that's attached to it?
Appears to be the wiring instructions. The account name, Wilson Law Group LLC IOLTA account. Bank is South State Bank in Bamberg, South Carolina, and South State's routing number. Contact information is Chris at wilsonlawgroupsc.com, Gail at wilsonlawgroupsc.com.
And what is the source of funds for this $350,000?
Again, it's the bank's internal account, general ledger account, loan not on system.
Loan out on system. It's bank money.
Yes, sir.
And at this time, was there any documentation whatsoever justifying $350,000 of bank money being given to the defendant to send to Chris Wilson?
No, sir.
When you had a discussion at the board meeting in August of 2021, were there any representations made to you about the purposes for some new loan to Alec Murdaugh?
Yes, there were.
And what were you told the purposes were?
Repairs to beach house.
Repairs to the beach house?
Yes, sir.
And who told you that?
Russell Lafitte.
Okay. And did he tell you at any time that it was $350,000 to Chris Wilson to put some fees back?
No, sir.
Did he tell you that at any time it was $400,000 to cover a negative $347,000 overdraft that the bank had been paying for him since June of 2021?
No, sir.
I'll show you what's been marked as Exhibit 359, see if you recognize this.
This is the customer copy of a cashier's check number 287933 in the amount of $400,000 dated 8/9/2021.
All right, and does it have what appears to be a copy of a sticky note on there?
It does.
And whose writing is that? Do you recognize it?
Russell Lafitte's.
All right, and there's a reference to Green Swamp stock. Is that correct?
Yes, sir.
Do you know what that is?
It's a hunt club. That's shares of a hunt club, a share of a hunt club.
I'm going to show States 363 up on the screen, and I showed you this previously, but what is this document?
That's the business purpose statement.
All right. And what does it say? Is this for that loan in which the application is being drafted after the fact?
Yes, sir.
And what does it say the purposes are?
Purpose is investment.
All right. And what, again, had you been told as a board member was the purpose of this supposed new loan?
Repairs to the beach house.
As you've come to review all of this information, was any of that $750,000 used for any repairs to the beach house?
To my knowledge, no.
And when it's $750,000, we're talking about the $350 of the wire to Chris Wilson, correct?
Yes, sir.
And then the $400,000 to cover the overdraft, and then a little bit.
Yes, sir.
At some point in time, was there any discussion about collateral for this particular loan?
Yes, there was.
All right, and tell me about those discussions. What was your understanding of collateral for these loans?
The collateral was to be a second mortgage on the beach house and the one share of Green Swamp stock.
And as things progressed, did any of that change as far as collateral?
We did not put the mortgage on the beach house.
And why was that?
Mrs. Murdaugh was deceased, and she had an ownership interest in the beach house.
At some point in time, I'll get to that in a minute. So ultimately, this particular loan, did it have any collateral at all?
Nominally, the Green Swamp stock.
And why do you say nominally?
It had been cross-collateralized to other loans.
In your experience as a banker, is it common or usual to provide a new loan to cover an overdraft like was done in this case?
Not to this magnitude, no, sir.
Let me show you what's been marked as States 357 and see if you recognize this.
These are minutes of the directors of Palmetto State Bank, Tuesday, August 17th, 2021.
Your Honor, this time I would offer States 357 into evidence, I believe, without additional objection.
Greg, no additional objections.
Submitted.
All right, is there a discussion of the defendant in this particular document?
There is.
Now, we'd seen one before, which was an executive committee meeting in August. And was this the subsequent board meeting?
Yes, it was.
All right. Let me put that up on the screen. You have a screen right there. If you can
Yes, sir.
see that. If you have problems seeing it, just let me know and I'll bring it back to you, okay?
Yes, sir.
All right, and this is the discussion as it relates to the defendant right there?
Yes, it does.
All right. And real quick, what's the second sentence right there in this particular discussion?
Russell L. Lafitte stated that his intention is to sell the farm.
All right. And down here at the bottom, what does that sentence right there say? Starting with Elizabeth.
Elizabeth Malinowski commented the $750,000 loan did not appear to have been approved by the executive committee.
All right, and then what's the next sentence?
Russell Lafitte explained that 3 of the 5 members approved the loan.
All right, and so with 3 of the 5 members approving the loan, were you on the executive committee at that time?
I was, yes.
But you were not informed of any of these monies being expended or this after the fact documentation or any of it, is that
No,
correct?
sir.
As some of these things ultimately came to light in the months following, what happened to Russell Lafitte?
He was terminated from the bank.
And is that what led to you ultimately becoming CEO?
Yes, sir.
In the course of your review as CEO of what had been going on at your institution, did you become privy to information that Russell Lafitte had been converting trust account checks from PMPD made out to Palmetto State Bank?
Yes, sir.
And that those checks had been converted, that those were client money checks and had been converted for the benefit and for the personal use of the defendant?
Yes,
And is that practice improper?
it is.
I'm going to show you what's been marked as States 366 to your testimony. See if you recognize this document.
This document is a printout from our loan accounting system, which summarizes the loans outstanding to Mr. Richard Alexander Murdaugh
As of a particular day.
as of June 7, 2021.
Your Honor, this time I'd move States 366 into evidence.
No additional objections.
All right, let's take a look at it. Can you see that all right?
Yes, sir.
All right, there's certain numbers that are highlighted here. Is that the balance as of that particular day?
It's the principal balance, yes, sir.
All right, and so that number right there is what?
$104,119.80.
And the balance right there is what?
$806,666.26.
And the balance right there is what?
$195,171.64.
And that balance right there, what is that?
$999,650.94.
And then finally this.
$91,368.90.
This particular one right there, is that a line of credit?
Yes, sir.
And how much, what's the limit on the line of credit? Line of credit's kind of like a credit card. It's got a limit on it, right?
That's correct.
What's the line of credit? How much was it for?
$1 million.
And what was the balance on it?
$999,650.94.
Pretty much maxed out.
Yes, sir.
Going back to States 365, we've got this one right here. What was the balance on that one with this memo that was prepared around August of 2021?
That loan balance is $599,400.
And was that also a line of credit as well?
It was,
And what was the limit on that line of credit?
I believe, $600,000.
So that one was pretty much maxed out too, correct?
Yes, sir.
Not listed on States 366 are two that are on this memo. One says Zero United and one says Redbeard. Are you familiar with what those are?
Yes, sir.
And are those business entities?
They are.
And do you know who those are associated with?
Mr. Murdaugh was a partner, member of the LLC.
All right. And had those two loans been charged off?
They had been,
And to your understanding, those entities own real property?
yes, in Berkeley County.
All right. When you say charged off, what does that mean? Explain that very quickly to the jury.
In the banking, if the loan becomes uncollectible for whatever reason, the borrower suffers financial difficulties, other issues, the bank will at some point in time make a determination whether to take it off its books and subsequently charged off.
Okay. Did the bank foreclose on the properties under those particular two entities?
We did not.
All right. And so it takes it off the books, so it stops accruing interest and late charges and all that kind of stuff, right?
Actively, yes, sir.
Actively at least, correct?
Yes.
And did the defendant, was he still though expected and required to keep paying on those particular loans?
It didn't absolve him of his obligation, but he periodically made payments.
Periodically made payments on
Yes.
those loans. If the defendant had tried to sell those properties or something like that, what if anything would the bank would have been entitled to in the event that was attempted?
We would have been entitled to the outstanding principal balance at the time, plus lost interest and any late fees and charges.
All right, so that would have to be applied against any sale price before those things could be, that property could be sold. Right?
Yes, sir.
And it would be somewhat higher than the numbers on this memo, is that right?
Yes, sir.
One of the things on here is this particular loan right here. And what is that for?
A house in Edisto.
And in April 2021, was there any sort of thing going on with that particular loan that needed to be addressed?
The loan had matured.
It had matured? And explain to the jury what that means.
At that time, the balance of the loan, the note itself had reached its maturity date, and the borrower would be required to, the bank and the borrower were required to come together and determine what they wanted to do, either renew it, extend it, whatever.
All right, and it had not been paid off,
It
correct?
had not been paid off, no.
Since it matured, it either had to be renewed or paid off, correct?
Yes, sir.
And because of that need for a renewal, had an appraisal been sought in April of 2021?
Yes, that's my understanding.
All right, we'll show you exhibit, need to show it to defense counsel. Show you what's been marked as exhibit 364.
We're back in 30 seconds.
Did you see this report from overnight?
Yeah, I think I saw we're leading with this.
Is that the Edisto house we're talking about?
Yes, sir, it is.
All right. And is this, and that's the appraisal request form underneath it?
It is?
And that relates to the renewal of the existing loan on Edisto, is that correct?
That is correct.
Did this appraisal have anything to do with this $750,000 that you've been telling the jury about?
No, sir.
This was already in existence because of an existing loan, is that correct?
Yes, sir.
And Your Honor, this time I would offer States 364 in evidence.
Additional objection.
Submit it.
Almost done. Real quick, one I forgot, states 360. We'll show this to you real quick, and then we'll get to the beginning of the end. Yeah, can you tell me what that is?
Yes, sir. This is, I'm sorry, it's the checking deposit ticket of a $400,000 deposit going into an account, last four digits 6092, in the name of Alex Murdaugh. Underneath that is the cashier's check itself, which accompanied the deposit ticket. Cashier's check number 287933 in the amount of $400,000 dated August 9th, 2021.
Your Honor, this time it all for states 360.
No additional objection, Your Honor.
Submit it.
All right, and this is that $400,000 that covered the big overdraft, is that right?
Yes, sir.
All right, I'm going to show you one last series of documents here, one at a time. Show you first what's been marked. Has not been marked. Show you what's been marked as states 367, and is that a statement balance for an account in the name of Alec Murdaugh?
It is. It's Alec Murdaugh, farm account number 1646.
All right, and on June the 7th, 2021, can you tell me the balance in that account?
The balance of the account is a negative $2,458.23.
Okay. Your Honor, this time I'd move to admit states 367.
No additional objection.
Submit it.
I'm going to show you what's been marked as 368 and see if you recognize that document.
It's a copy of an account statement for account number 6092 in the name of Richard Alexander Murdaugh.
All right. And can you tell me what the account balance is on June 7th, 2021?
On June 7th, the balance in the account is $2,185.23.
All right, Your Honor, this time I'd move to admit states 368.
No additional objection.
Submit it.
I'm going to show you what's been marked as states 369, excuse me, and see if you recognize, or you can tell me what the balance, what that document is. I can get a question now, Vinci.
This is the account statement for a health savings account. Last four digits 3094, also in the name of Richard Alexander Murdaugh.
All right. And can you tell me what the balance of that was on June 7th, 2021?
On June 7th, it would be $7,540.61.
And that's a health savings account?
Yes, sir.
Can that be used for any expenditures, or is that limited? Is that a special type of account that's limited to medical expenditures?
It's a special account generally limited to medical expenditures.
Your Honor, this time I'd move states 369 into evidence.
No additional objection.
Submit it.
I'll show you what's been marked as states 370. And see if you can tell me what that particular document is.
Another account, copy of the account statement. This one is the last four digits 6649 in the name of Alex Murdaugh.
All right. Can you tell me what the balance is on June 7th, 2021?
The balance on June 7, 2021 is $62,115.06.
And then finally, I've got a set of documents. And Your Honor, real quick, I'll move states 370 into evidence.
No additional objection.
Submit it.
All right, last one. Can you tell me what that particular document is?
It's a copy of an account statement number 5109 in the name of Margaret Maggie Murdaugh.
All right, and just real quick, for the record, I'm having you look at states 3. 371. All right. Can I take a look at it again?
Same account number, Margaret Maggie Murdaugh.
All right. And just go back. Can you tell me what the account balance is on that particular account, at least as of, go back to the first one, of June 24th, 2021.
June 24th, 2021, the balance was $23.97.
Your Honor, at this time I've moved states 371 into evidence.
No additional objections.
It's admitted.
All right, I'm almost done. Mr. Malinowski, if at any point in time, if the bank over the years at any point in time had become aware that Alec Murdaugh was having a bank official take client trust money checks and convert them into cashier's checks and other transactions for his own personal use, what would have happened?
Certainly would have a significant conversation in the bank, and we would have asked the bank official to stop doing that.
All right. And what would have happened if you uncovered that the defendant, Alec Murdaugh, was stealing client funds through that method?
That would have certainly affected his borrowing relationship with the bank and any other relationship he had with the bank.
Would they, if you found out the defendant was stealing, would you loan another dime to him?
No, sir.
If you found out that the defendant had created a fake business account in the name of a legitimate entity and was routing and stealing client money through that account and converting it to his own personal use, at any point in time, what would have happened with his relationship at the bank?
It would have ceased.
Would the bank have loaned him any more money?
No, sir.
If the bank found out that the defendant had been forced to resign or been fired from his job, what would have happened with his banking relationship? Would the bank have loaned him any more money after that?
No, sir.
If the bank had found out at any point in time that he had been disbarred, what would have happened to that banking relationship with that defendant?
It would have ceased.
Look at exhibit 368. What account number is that? What's the last four digits of that account number?
6092.
And on June 7th, what's the balance?
$2,185.23.
Looking at exhibit 356. What's the account number?
6092.
And by the time that applied for deposit comes in, what's the balance on August 6th, 2021?
On August 6, 2021, the balance is a negative $347,784.67.
Hold on for me 1 second. Thank you, Mr. Malinowski. Please answer any questions the defense may have.
Ladies and gentlemen, we have you go to the jury room for a break. Please do not discuss the case.
Rise and come to order. Please be seated. Your Honor.
Yes.
That would be heard outside the court's presence.
Okay. Yes, sir.
This is something new that has come up, Your Honor. I'm sure Your Honor recalls the testimony of Shelley Smith this Monday. And her testimony was, let's say, somewhat malleable. We've discovered late last night that a GoFundMe page was set up for Ms. Smith, soliciting donations until the wording was changed during the testimony of the last witness. It read that my mother was caretaker for Alec Murdaugh's mom. She recently had to testify against him, and goes on to say, I want to reward her for her bravery and honesty. The very first donation made on this GoFundMe page, which was made shortly after it first went up last night, was made by attorney Mark Tinsley, who paid her $1,000, presumably following the description of this in consideration of her testimony. And Your Honor, I have, if you want, printouts of the screenshot showing that. Shortly after Mark Tinsley's name actually appeared as the donor for $1,000, he removed his name and it now appears as anonymous. But I'm told the Attorney General has confirmed with Mr. Tinsley that he admits he did make this payment to the witness in the middle of trial, who is still under subpoena.
And therefore,
Your Honor, and therefore, the defense would move to exclude his testimony. And
on what basis?
Your Honor, the legal standard here is difficult to find. I cannot, searching Westlaw, find a single case in which a prosecutor has tries to put to the jury a lawyer who has already testified he has a direct financial interest in the outcome of this case, who is also making monetary payments to prosecution witnesses during the trial. Your Honor, I believe that this is a question of first impression. And because it's a question of, I understand that the facts here in this case are disturbing, but because it's a question of first impression, I would respectfully urge the court to keep in mind the aphorism that bad facts make bad law. You know, a prosecutor, to my knowledge, to Westlaw's knowledge, has never before done this.
What's improper about what he did?
About what Mr. Tinsley did?
Yes.
He made a financial payment to a witness in the middle of a trial that he has a financial interest in the outcome of. He has testified. Who is under subpoena. She's still under subpoena. He made a $1,000 payment as a reward for her honesty, testifying in a matter that he has testified that he has a direct financial interest in.
Well, that would be good fodder for cross-examination.
Your Honor, I respect the court's ruling.
I'm not going to strike his testimony. It may be good fodder for cross-examination.
Yes, sir. Thank you, Your Honor.
Yes.
One other issue, given the testimony in the in-camera proceedings, we would ask that he be precluded from offering testimony about focus groups on the verdict for the beach matter, speculation about fixing a jury in Hampton County. These matters don't go to the motive purpose that his testimony is being offered for, and would be prejudicial.
Well, I'm loath to attempt to screen testimony in advance. Lawyers ask questions, lawyers object, judges rule. So you've sounded a warning to the state that you object to that testimony, and if such a question is asked and an objection is made, then I will rule on the objection.
Yes, Your Honor.
Anything else?
From the state, Your Honor.
present, sir.
Hey, cross-examination.
Please record.
Yes, sir.
Good afternoon, Mr. Malinowski.
Mr. Riven.
The $750,000 loan that was made in July of 2021, that was approved by 3 members of the executive committee, was it not?
Yes, sir.
And the 3 members that approved that loan were Mr. Charlie Lafitte, Mr. Russell Lafitte, and Ms. Gray Henderson. Is that correct?
That's correct.
And Mr. Charlie Lafitte was chairman of the board of the Palmetto State Bank at the time. Is that right?
Yes, sir.
He's the largest shareholder of Palmetto State Bank.
Him individually, no.
He wasn't the largest individual.
Nope.
Did he own 30% of the bank?
Not individually, no.
Okay. And then his son was Russell Lafitte,
That's correct.
and his daughter was Gray Henderson.
Correct.
And it was his position that if Alec Murdaugh wanted a loan from Palmetto State Bank, that the bank would loan him the money. Is that correct?
That was his opinion.
And Alec Murdaugh was a member of PMPED law firm. You're aware of that at the time?
Yes, sir.
And PMPED law firm was one of the most, largest customers of the bank.
It was a large customer of the bank.
And the partners in the firm all had banking relationships with the bank, correct?
I'm aware that many did, yes.
And oftentimes when members of the law firm had clients who needed to borrow money before they got recoveries in their case, the partners from the firm would send them to the bank, and the bank would loan money on future recoveries. Are you aware of that?
Yes, I am.
And so the firm was good business for the bank.
It was a good customer.
And the bank, in turn, was provided good services to the members of the firm.
Yes, sir.
And if it meant, getting a loan in a rush without having all the I's dotted and the T's crossed, I mean, that would happen. Isn't that right?
Not to that magnitude, no.
Well, it certainly happened with Mr. Alec Murdaugh in July of 2021, right?
I believe in August of 2021.
Well, the loan was made, the money was provided to Mr. Alec Murdaugh in July of 2021, right?
$350,000 was provided in with that wire transfer. I subsequently knowledge of.
And the documentation was essentially loan not on the books, or what's the acronym?
Loans not on system, LNOS.
Right. But it's a loan, it's just not on the system.
It's an advance from a general ledger account.
To be documented as a loan down the road.
One would hope, yes, sir.
And that's what happened here
Eventually,
in August.
in August.
Now, Alec didn't work for the bank, did he?
No, sir.
He didn't represent the bank, did he?
To my knowledge, no.
He was just a good customer of the bank. Is that right?
Yes, sir.
And the bank treated him like a good customer because that was in the bank's interest.
Yes, sir.
Now, you said something on direct that I want to follow up on. And my notes say that after the tragic murder of Maggie and Paul, that the bank undertook a loan review of Alec's loans. Is that right?
In response to the August 9th email, yes, sir.
Well, the August 9th email was triggered because of Maggie and Paul's murders?
That and other information, yes, sir.
Okay, and what other information?
I think Mr. Norris Lafitte had asked some questions or had conversations with individuals and wanted to know the full accounting of the bank's relationship.
Okay. And one of the factors that Mr. Norris Lafitte included was he had just lost his wife and son, and let's take a look at his standing with the bank, loans outstanding, et
I
cetera.
think it's a fair statement, yes, sir.
Okay. Up until June 7th, 2021, the bank was not examining Alec's loans, were they?
We're not scrutinizing them, no, sir.
Yeah. He did he and Maggie had a loan review from the bank, whether they knew it or not, back in July 10th of 2020, correct?
Yes, sir.
And I'm going to show you Defendant's Exhibit 91 and ask if this is the loan review that was done, documented to the Executive Committee on July 10th, 2020.
Yes, this is a copy of a loan review prepared by Gray Henderson, the relationship summary of Alec Murdaugh and Maggie Murdaugh,
Thank you. And what's the date?
2020.
July 2020. Your Honor, I would move Defendant's Exhibit 91 in evidence at this time.
It's admitted.
Just put the front page up there. And so, Doug, go down so we can see keep going. There you go. So to the Executive Committee on July 10th, 2020, who was on the Executive Committee with the bank?
At that time, Charlie Lafitte, Russell Lafitte, Gray Henderson, myself, I believe Scott Swain was on it at that time.
And it's a 5-member Executive Committee?
Yes, sir.
And I think you mentioned earlier that does it take the majority of the committee to approve loans over a certain amount?
Sitting in a meeting, yes, sir.
Excuse me?
In a meeting, yes, sir.
Okay. And Gray Henderson is preparing this loan review for Alec Murdaugh, right?
Yes, sir.
It says Richard Alexander Alec Murdaugh is a lifetime resident of Hampton County. He and his wife, Margaret B. Maggie, recently sold their home in Hampton and moved their permanent residence to their farm in Islandton. Alec is a respected partner with Peters, Murdaugh, Parker, Ellsroth, and Dietrich law firm. They are currently involved in a wrongful death suit involving their youngest son, Paul, in a boating accident. Civil case is still pending. So that was the background on this.
That was a general summary of current situation.
And then the reviewed financials related to their tax returns and whatnot. Is that correct?
She's just stating in there that what financial information we have on file.
Okay. And then you go through each outstanding loan. Is that right?
It's a summary of the loan. Yes, sir.
Okay. And the first loan is can you tell us what that is? Williams Island on St. Helena?
We had a loan, I believe that loan was a joint loan with a gentleman by the name of Barrett Bowler, secured by 2 or 3 little islands off St. Helena.
And that loan's in good standing? Says
All payments made as agreed. Yes, sir.
Okay. And now the next loan is a loan on, that's the Edisto Beach House, is that right?
Yes, sir.
And here it says that the home appraised for $440 in February of 2016. And current balance on the note was $206,000. This is in July of 2020, is that right?
That's what it says. Yes, sir.
And it says they've been 30 days late 3 times. I think that's what it says.
Yes, sir.
I guess if you go over 30 days on your loan payment, that's a strike against you when
It gets noticed.
it gets noticed. But that house at Edisto, the bank had a mortgage on it dating back at least for some time, right?
Yes, sir.
And you know, it recently sold,
Yes,
that
sir.
house. And do you know the sale price?
I think it was just below $1 million.
Okay. So the bank's in a pretty good position here in July 2020 with $200,000 on what sold a couple of years later for $1 million, right?
Many years later, but yes.
How many years later?
Well, I think it occurred in 2022, and this is in 2020.
2 years then? To go with that?
Yeah, I'll go with that.
Is too many?
In the real estate market, 2 years can
Right.
be a long time.
All right. Then the next loan is first mortgage on, I don't know what you're doing there, Doug. It's on 856 acres and the second mortgage on 914 acres. That's the Moselle property. Is that right?
Yes, sir.
And what's the outstanding balance of that loan?
$719,769.16.
And what kind of value do you have there?
Good value in it. If the appraisal is $3.3 million.
Now, you know, there's a contract on that property today.
I understand there is, yes.
You know what it is?
No, sir, I don't.
Okay. You know it's more than 3.3?
I don't know that.
Okay. Bank still has a mortgage on it?
We do.
Okay. You turn the page, Doug? That's the last one on there. And here's another loan. And I guess that's part of the same. That's another tract at Moselle with additional, was that the same loan? Are we talking about a new loan here?
I believe we are, yes.
Okay, and what is this?
This balance is $888,527.08.
Okay. And what's the value we have on this?
Assume it's the Moselle 3.3 million from the preceding loan.
Okay,
Two mortgages on the single property
all right.
or the acreages.
And then the conclusion here, the summary is Alec and Maggie Murdaugh are longtime customers of Palmetto State Bank. They've had some late payments, but in my opinion, those are mainly due to Alex being hard to reach and set appointments to sign the paperwork. The majority of his payments are set up on an annual basis because the law firm makes their distributions in December. Now, let me ask you about that. Were you aware that a lot of the partners at the law firm who owe money to Palmetto State Bank just pay once a year because that's really when the bulk of their income is generated or received?
That's my understanding. That's correct.
And so this was not special just to Alec, but it's not, but other partners at the firm have the same payment plan.
You're setting up the repayment to coincide with the receipt of their income or the bulk of the income.
Sure. And it says the Murdaughs have always paid their loans to the bank, and I do not see that changing. And it says, depending on the outcome of the pending lawsuit, they may have to liquidate some assets, but our loans are more than sufficiently collateralized. Meaning you've got plenty of security. Is that right?
In 2020, yes, sir.
Okay. Thank you. Alec and Maggie have, to your knowledge, never been turned down for a loan at Palmetto State Bank.
My knowledge, they have not.
Now, there were some loans that were, I guess, written off, as you said, or charged off, where Alec was a member of a partnership, LLC, some sort of structure where there are other partners involved and that those loans went in default. Is that right?
Yes, sir.
But Alec kept paying on those notes, did he not?
Periodically, he'd make payments.
Did any of the other partners in Redbeard or United, were they making payments?
To my knowledge, no.
To your knowledge, it was only Alec that was making the payments.
Yes.
To your knowledge, was there any reason in the world for Alec to believe that in June of 2021, if he needed additional money from Palmetto State Bank, that he couldn't just go down there and talk to Russell Lafitte or Charlie Lafitte and ask for a loan?
In June of 2021,
Yes, sir.
I don't see any reason why he couldn't have that conversation with Charlie and Russell.
And he had, to your knowledge, never put on any notice that your business is not welcome here at Palmetto State Bank in June of 2021. Is that right?
In June of 2021, that's correct.
In June of 2021, the bank is fully collateralized on the outstanding notes.
With the exception of the one where he was a co-borrower, I believe, with his father. I think that was an unsecured loan.
And his father being Randolph Murdaugh.
The third, yes, sir.
The third, yes. One second, Your Honor. I have no further questions, Your Honor.
Redirect.
Very briefly, Your Honor. You're asking about whether Alec made some year-end payments on some of those charged-off loans, correct?
Yes, sir.
And your review was some of that money that was used to make those payments ultimately converted money from client funds?
I believe so, yes.
You were asked whether or not in June of 2021, whether Alec could have talked to Charlie Lafitte or Russell Lafitte about another loan. Is that right?
In June of 2021, yes.
In June of 2021. At that point in time, had it come out that he had been stealing client funds for years?
No, sir.
Had it come out that he had been disbarred?
No, sir.
Had it come out that he had been diverting fees from his law firm?
No, sir.
Had it come out that he had been forced to resign from his law firm?
No, sir.
If any other things had come out, would the bank continue to have loaned him money?
No, sir.
Mr. Griffin asked you if Alec had been a good customer. Correct?
Yes, sir.
When all of this crashed and burned, was the bank left holding the bag for all these uncollected loans,
Yes, sir.
including the $750,000?
Yes, sir.
Nothing further. Thank you.
Mr. Malinowski, the bank had mortgages on the properties that we just went over, did it not?
They did.
And those mortgages didn't disappear when Alec Murdaugh, when all this came to light, did they?
No, sir.
All right. Thank you.
May I step down?
Thank you.
May I call your next witness?
Thank you, Your Honor. State calls Mark Tinsley.
Raise your right hand. Repeat on the Bible. Do you affirm the testimony about to give this court of this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat and witness stand. State your name again for the record. Spell your last name, please.
Afternoon, Your Honor. My name is Mark Tinsley, Tinsley.
Mr. Tinsley, how you doing today?
Good.
Introduce yourself to the jury a little bit. Please tell them a little bit about yourself, where you grew up, where you went to school, and a little bit about your profession, please.
Sure. I said, my name's Mark Tinsley. I'm a lawyer. I practice in Allendale. I've been there since about 2000. I'm originally from,
Mr. Tinsley, get that mic a little bit closer to you.
well, the mic's short and my knees apparently are long because this is the most uncomfortable place to sit.
You can bend it down a little bit, maybe,
Yeah. I'm from Anderson originally. I went to Clemson. I carried an orange book bag when I was at Carolina. I went to law school there. I graduated in 98. I worked in Columbia for a couple of years doing primarily insurance defense work. You've heard a lot of plaintiffs' lawyers. So I would have been one of the lawyers representing an insurance company that was hired to or had the coverage on somebody who was getting sued, or I would have dealt with coverage. Is the specific loss covered or something? So that's primarily what I did for the first 2 years. One of my good friends was originally from Barnwell. I made my way to Allendale in 2000, and I've been there ever since.
And so since Barnwell, have you been in a law firm? You've been in practice? Tell us a little more about that.
I have. I practice with Gooding and Gooding. When you live in a small town, you do all kinds of things. I have the luxury of having a successful practice and being able to go to different places and handle cases. I try cases. I try truck wrecks. I try highway defect cases where there's something wrong with the way that the contractor had not really designed the road, but maintained the road, and somebody gets catastrophically injured. I tried bad faith cases where an insurance company has coverage, but for some reason or another, they don't do what they were supposed to do under the contract, and their insured gets harmed as a result or suffers a loss. And so, I pick and choose, but when you're in a small town, you help people. And so I end up doing all kinds of things. There's no case that's too small, no case that's too big. If I can help you, I try to help you.
All right. Over the years, being a lawyer doing this kind of work in this area, have you had call to get to know the lawyers and what used to be known as PMPED?
I have. There's only 17 miles basically between Allendale and Hampton, small bars. At one time, I think there were really only 4, maybe 5 lawyers in Allendale, and about twice, maybe it ultimately gets up to 3 or 4 times that many in Hampton, but it's a small bar. And I had occasion to work with you. You saw Ronnie Crosby, I think, yesterday. I've handled a number of cases with Ronnie Crosby. You've heard Lee Cope's name mentioned. I've had cases with Lee Cope, but I knew everybody.
All right. And did that include the defendant, Alec Murdaugh?
It does.
And how long have you known him?
It's hard. I heard Chris Wilson this morning. I don't remember exactly. I came in 2000. I always remember him being there. So sometime shortly after I came to practice in the 14th Circuit.
And do you see him in courtroom here today?
Sure. He's immediately to the right of Mr. Harpootlian.
Can the record reflect he's identified the defendant? Over the years, as you knew Alec Murdaugh, did you ever do anything professionally, either with him or against him?
I hate to be a lawyer, Mr. Waters. I have. I had a case where a defendant was in default, and Alec was a special referee, meaning you may remember Chris Wilson said in that Mack Truck case, one of the defendants didn't answer. And so if you get sued and you don't respond at the right time, then you're in default. And so the other side by default wins generally. And Alec was my special referee, meaning this guy had been accused of selling some property under lien. He was arrested at his job, and we sued a company called Southern Finance that incidentally went into bankruptcy. It's a long, complicated story, but we got reversed, and so I didn't do that again.
But just generally, have you had? Go ahead.
Well, yeah, I mean, but I didn't handle cases with Alec. Unlike say Ronnie or Lee Cope, and we just didn't have that sort of relationship. I guess he and I did so much of the same thing. I don't recall a time over the last 20 years where we worked on a case together.
Being a small bar and doing the same kind of thing, though, y'all are generally familiar with one another and the type of cases y'all were handling and that sort of thing?
Oh, absolutely. I mean, it's a small bar and you go to the roster meetings, you know what everybody's doing, you see what cases they have. Yeah, absolutely. You know, if they have a success, a big case or a failure.
You ever been in court when Alec was doing a closing argument?
Yes, probably a couple of times. There was, he tried a case in Allendale. It was the first case, I think it was 98 that the Allendale courthouse burned. The story is that Judge Peoples from Barnwell was going to sentence some guy for a drug offense, and Judge Peoples was very strict on drug offenses. And so the guys who were going to be sentenced on Monday decided Sunday would be a good day to burn the courthouse. So they burned the courthouse. And so many months later, I think Judge Peoples ended up sentencing them. At any rate, they rebuilt the courthouse. And so the first case that was tried in 2005, Alec tried. And I was there when he made his closing argument.
You were present when he did the closing on that?
I was.
Did he get emotional during that closing?
He cried.
Relevance.
Any response?
Your Honor, I think this is just relevant to the defendant and his practice as a lawyer, background information. And I think there's been a lot put in issue about the defense about that as well. And I think this is fair from this witness.
Yeah, we're in the year 2000.
2005, March of 2005, it was.
Same objection.
Let me ask you just a little bit about, though, being in this kind of type of work in a sort of small bar in a small area. And you said y'all are generally familiar with what each other are doing to do similar work.
I think so.
And when you're, are there any sort of documentation at the court, jury rosters, or anything like that, or rosters that you can pay attention to and have an idea of what each other's doing?
Well, I mean, it is a roster. It is a list of cases. Generally, a case comes up for trial, not in civil cases I'm talking about. Supposed to be about a year old. It's usually longer than that, but they go on this list. And so come Monday morning, all the lawyers would show up. There's 100 cases. And so you see what's coming up, who has what cases. And in Hampton in particular, Alec usually seemed like a majority of the cases on the Hampton roster. His name would be on them anyway.
And being a small bar and being, part of that, kind of doing the similar work, is it not uncommon for you to have some knowledge of some of those cases and for others to have knowledge of the cases you're working on?
Sure. Lawyers are the biggest gossips in the world. I mean, everybody knew what everybody was doing.
If you see a case that's on there and then it gets removed or disappears, does that indicate anything to you?
No. I mean, it indicates they were settled. But oftentimes, when you go through the roster, there's actually a notation. The case is settled. The judge will sign what's called a formal order, which just administratively disposes of it, takes it off the roster so that it doesn't stay on that list.
And being as part of that small bar, and this is kind of work you do, that's something you generally pay attention to, as other lawyers part of that area do as well.
Well, it's a lot like sitting in here. I mean, it's easier to pay attention than to just sit there bored. So yeah, you pay attention to it.
Are you familiar with what's been known as the boat case?
I am very familiar. I represent the Beach family. And so I filed the boat case.
And you say the Beach family, are you talking about the family of Mallory Beach?
The family of Mallory Beach, that's right.
And is she the young woman who died in the boat accident?
She did.
And what was the date of that accident?
It was the early morning hours of February 24th, 2019.
At some point, you said you were representing the Beach family. At some point, you were approached by the Beach family?
I was. Shortly after the wreck, there was an incident on the causeway. So this this boat crash happens, there's a bridge called, you go over Archer's Creek. Archer's Creek is it's a creek that separates Paris Island, the marine installation, from, I guess that's Port Royal. And the boat crash happened at that bridge. There's a road, if you can imagine the causeway, there's an old road that goes down to the base of the bridge. And after the boat crash, the law enforcement had cordoned off, had a rope up or yellow flag, yellow taping up. And so Miss Beach wanted to go down to see where her daughter had died. And she wasn't allowed to.
Objection, relevance, 403.
Objections overruled.
Please continue.
She wasn't allowed to go down to the bridge.
She was
told
not?
She was not. She was told it was a crime scene, and she couldn't go down there.
All right. What else did she, and when she was hiring you, what else did she report?
Almost immediately thereafter,
Hearsay.
For the truth of the matter, asserted the effect on the listener and the reasons for the actions he took, which has become relevant in the boat case.
Only argued when requested by the court.
My apologies.
Objections overruled.
almost immediately thereafter, a car pulled up driven by Alex's father. His wife was in the front seat. Alex's wife, Maggie, was in the front seat. They were waved down to the bridge, and that caused her a great amount of distress.
Did she ultimately hire you to represent her?
That day I got involved.
At some point, as you get involved, do you start to investigate the occurrence?
I did. I started to investigate, but I started to try to put pressure on law enforcement, which is, I'm drawing a distinction there almost immediately, because the concern was that it was going to get covered up by the Beach family, and they didn't want that to happen.
Your Honor, I would object to these references to covering up. It's not relevant to the motive purpose for this testimony, and it is prejudicial under 403.
Sustain the objection.
And strike the previous response.
Objection is sustained. You may proceed.
Yes, Your Honor. Just generally, you investigate the case, is that
I did.
correct? And at some point, did you reach out or have any discussions with anyone who was representing the defendant, Alec Murdaugh?
I did. Well, I've talked to a number of the partners, but after
When you say partners, you're talking about PMP?
Yeah, yes, I'm sorry.
All right.
But eventually I came to know that Danny Henderson was appointed as Alec's personal counsel, who was one of the partners. You may remember there was a video from Alec in the front seat of the law enforcement car, and the arm that reaches up and squeezes his shoulder while he's crying. That's Danny Henderson.
All right. And did you and Danny Henderson, did he have any documents for you to review?
He brought me all of the insurance policies for all of the insurance that Alec had in place at the time of the boat crash.
And for what reason did he bring you those documents?
Well, when you do what I do, we can't turn back the hands. We can't undo what's happened. And so, the best that you can hope, and when you get a case like this, this kind of loss, nobody gets what their case is worth, if that means anything. I mean, nobody would willingly trade place with these people for money. But that's all that you can do in a civil case is recover money. And so some things are covered by insurance, some things are not. And so many times when we are drafting lawsuits, we want to know what insurance there was so that we try not to destroy the ability for the insurance to apply in the beginning. So that would have been the reason I was looking at the insurance.
His attorney, Danny Henderson, brought the defendant's policies to you to review. Is that correct?
It seems like it was a week, 10 days after the boat crash.
All right. And did you review those?
I did.
And what if anything, did you find in those documents?
It did not appear to me that that he had any coverage other than there was a policy with Progressive, a watercraft policy that applied to the boat. It was $500,000, and it was offered by Progressive immediately. When you have a catastrophic loss, it's not unusual that an insurance company will say, here's our money, take it, please, because they have an obligation to protect their insured if they can. The other policies that he had didn't provide coverage except for a for-hire hunting operation, which this didn't arise out of. And so,
What company was that with?
Philadelphia Insurance.
All right. And again, that policy was limited to what?
The occurrence, the accident, if you will, had to arise out of a hunting operation, a business operation. And even if there were some way to say that this boat ride this night did that, there were very specific watercraft exclusions that then excluded the coverage. So accidents are covered, but then you have all these exclusions that take the coverage away. So there was no coverage.
Did the defendant have an umbrella policy? First, tell the jury what an umbrella policy is very quickly, if you could.
An umbrella policy would be if you have a primary policy, say on your car, the umbrella policy would sort of be a coverage. It could be broader than your car. It could also apply to your house. Generally, that coverage is the limits are multiples of maybe what your liability limits are, and it could be broader than just your house. It could apply to your house and your car. So I don't remember. I think all of the coverage was with Philadelphia, and I remember reviewing all the policies. I don't remember if it was exactly what they were referred to this time.
Did you ever find out if the defendant had an umbrella policy or the status of that policy?
There was no coverage for this boat crash other than with Progressive on the boat.
Did the defendant have an umbrella policy at one time, to your review?
He had coverage. He had the coverage with Lloyd's of London and Nautilus immediately before, which was the coverage that was in effect when Gloria Satterfield fell at his house. And he had an umbrella policy there.
All right. And what happened to that policy, that coverage?
The policy came up for renewal. Normally they're a year. It comes up for renewal and this claim's still open. And so when it came up for renewal, the insurance company wouldn't renew the policy and they canceled it, which is why he then went and bought this hunting club operation or hunting for hire operation, whatever that policy was, but didn't really cover anything because he didn't have that kind of business.
In your assessment and judgment, would that Philadelphia Hunting Lodge policy provide any coverage for the boating accident?
It did not. I told Danny Henderson in November of 2019 that it did not. Philadelphia filed something called a declaratory judgment action where they go and ask the court to declare their rights, meaning we don't have any coverage. It's clear the policy doesn't apply. Judge, tell, in this case, the plaintiff, because they sued us, the Beach family, and they sued Alex Murdaugh and for a declaration there was no coverage. I refused to participate. I said I would just be bound by whatever the result was because I knew what the result was going to be.
Generally, at this point in time, what was your assessment of the defendant, how lucrative the defendant's practice was and his general wealth?
Well, so I believe that he was making lots of money. I told you that he had most of the cases. So if that's 50% or 60% of the cases that are actively resolving, he's actively making money. Money's coming in. Now, whether I knew that how the law firm worked in terms of they would get their money at the end of the year, that's not uncommon, but it doesn't really change the fact that he's making lots of money. And that didn't really change in the time that I knew him. It certainly hadn't changed in the years immediately preceding the boat crash. So by the last 3 to 5 years.
All right. And ultimately, with your review of the insurance coverages, the only one that you thought was applicable was which one?
The Progressive boat policy.
And how much was that?
$500,000.
And from your assessment of the case, was that going to be enough?
No, it wasn't. There were 6 people on the boat, including Alec's son, Paul. So there was one girl whose hand was pretty severely injured. She had about $130,000 in medical bills, a couple of surgeries. You had one boy who was thrown into the console and had a broken jaw.
Object to this, 401, 403.
Objections overruled.
And his medical bills exceeded 100,000. So, you got a death, you got 2 people with substantial medical bills, and there was just no way there was enough coverage at 500.
As a result of that assessment and your assessment of the defendant's lucrative practice and wealth, what, if any, goals did you develop for this particular litigation?
I don't know if it's as easy to answer that, but as I began to realize there was no coverage, it was clear that and oftentimes when you have someone who is very affluent, who has a lot of money, it's not uncommon for those people to pay in addition to what they have in insurance. And so Alec was going to have to pay out of his own pocket to settle the cases.
Did you ultimately file suit in this matter?
I filed suit, I think about a month after the boat crash. I filed suit before the criminal charges were brought.
Criminal charges against who?
Paul, I'm sorry.
And so in March of 2019, you filed suit?
I believe so.
And did you sue the defendant?
I did.
Without getting into the weeds too much, what's the basis of potential liability for the defendant?
So in the very beginning, if there was any chance at coverage, the allegations were that he knew that his son Buster, his older son Buster, who was 21 years old, had obtained a duplicate license, and that Paul was using that license to buy alcohol. And so it's sort of Alec's lawyers from time to time have characterized it as negligent parenting, but it's in the law, you have this idea that there's this thing called negligent entrustment. You know that somebody drinks, you know that he has a propensity to drink in excess, get drunk. You give him your vehicle, you've created a hazardous situation. And so that's the liability against Alec. And so what I did in the very beginning, in the first lawsuit, was I drafted it to try to see if there could be coverage, even though I didn't think it was going to be successful.
You testified that you'd made the assessment that the defendant was going to have to personally pay in this matter, correct?
He was.
Did you ultimately communicate that to his attorneys and to the defense in this case?
Multiple times and very clearly.
And in this case, I mean the boat case.
Yes.
Is there such a concept as a friendly defendant or a venue defendant or a placeholder defendant in civil litigation?
There is.
Can you just very quickly explain that to the jury?
It started, you first see the references back in, I think it was the 40s and 50s. And it was a way that if you're from out of state and you get sued in South Carolina, you have a right, rather than be in state court like we are now, you could have it, that case against you taken to federal court. And so oftentimes what people would do to keep the out-of-state person from taking it to federal court and rather keep it in the county where they knew everybody is you would also sue someone in state. And so it was a venue defendant. Now, and that kept the federal court from having what's called diversity. But in civil cases in state court, sometimes you do that. I mean, if there are 2 people driving a car, driving 2 cars, 2 people involved in the wreck, the passenger didn't cause the wreck. So you could sue both and let the jury sort out who it was, even though you believe that probably 99% of the liabilities on one person, or maybe all of it's on one person. Juries do crazy things sometimes.
Had you made it clear to the defense during this time that you were not considering the defendant just a friendly defendant or a placeholder defendant or a venue defendant?
From the beginning and very clearly.
And that meant you were seeking a personal recovery against him?
He was always going to have to pay and pay a lot of money.
Does your area of the law, do y'all have some sort of annual conference every year that many people involved in it attend?
We do. Michael Gunn mentioned it. I think he called it SCAD or SCAD. I don't know. So I called it the Trial Lawyers Conference. It was at the Westin at Hilton Head every year.
And what time of year does that, what month does that take place?
It's usually the first weekend of August. So that if that's first, second, third, or fourth, fifth, and sixth, but it's usually that first week of August.
In August of 2019, did you attend that conference?
I did.
And did you see the defendant there?
I did.
And did you have any conversation with him?
Normally, different law firms have dinners and groups of lawyers, because it's marketing too, right? I mean, you go and you have dinners and you take other lawyers out who may send you cases or get you involved in cases. And so after dinner, everybody sort of comes back to the hotel, and there at the Westin, there's a gathering area. And I think it was a fundraiser, either for Mr. Harpootlian or for Lindsey Graham. But there were the whole room of lawyers, and he saw me. And this is the first sort of gathering. There's a little tension, I think, generally in the room about it. And then he beelines across the room and gets about this close.
And what does the defendant say to you?
Hey, Bo, what's this I've been hearing about what you've been saying? I thought we were friends.
And did you respond to that?
I did. I told him that we were friends, that if he didn't think that I was going to do everything I needed to do to help my clients, he was wrong, and he needed to settle the case.
Was that conversation about your intent to seek a personal recovery?
That's when he said, what's this about what I've been hearing? I thought we were friends. That's what he was talking about. He didn't like the fact that I was saying he was going to have to come out of his pocket and pay.
Moving on to the following month, was there a mediation in the case?
The next year. So that was
2020.
August of 19. We don't have the mediation until September of 20.
At this point in time, the case has been filed, and without getting into detail, you're generally engaging in the discovery process. Is that correct?
We are, which is you go and you put witnesses under oath, and you take their depositions and you examine them and you collect documents and those sorts of things. But we were taking depositions, primarily of law enforcement, the people at the emergency room, that sort of thing.
What happened in March of 2020 that affected everybody?
Well, COVID began to shut the courts down. We continued to take some depositions, but ultimately, I think it was probably April, May, then we were sort of confined to our offices by then. So in March, we're still taking depositions of law enforcement, and it sort of slows down.
You continue to work on the boat case?
We did.
Continue to gather evidence and documentation?
I did. One of, there was a number of things that we knew existed that had not been collected by law enforcement and didn't appear to exist as far as law enforcement were concerned. And so, for instance, I subpoenaed from the Department of Defense, I believe, and ultimately got all of the federal government's documents of affidavits and things of witnesses that were out there from Parris Island. And
without getting into all the details of the evidence, were you gathering evidence that you felt make your claim against the defendant strong?
It did.
And did you share some of these, at least some of these findings with the defense?
Well, they're sitting in the room. I mean, they might not know it until I bring it out. The first lawyer asks questions, and then the person may or may not be completely truthful, and then you bring out the document. And so they're seeing it happen. And that's mainly with law enforcement. There were a number of law enforcement depositions where that happened.
As you're moving through the months of COVID and their shutdown and everything like that, is one of the things that you do is use a mock jury to sort of assess your case.
401, 403.
Objections overruled.
I did in this case.
All right. And some of this evidence that you felt was strong, did you sort of present that to this mock jury? It is just as a tool to help you assess how strong your case is and how likely it is of a recovery.
Yes, and I was specifically interested in Beaufort County, and I can explain that if you want.
Just very briefly, let's try not to get into the weeds too much, but just, yeah, if you can.
So the alcohol was sold by a convenience store, Parker's convenience store. And the Parker's lawyer at times would seem to act like Paul wasn't the driver, and at other times,
Objections overruled.
at other times, he would go after law enforcement specifically about that particular officer's connection with Alex Murdaugh or the Murdaughs in general. And so you really can't have it both ways, right? I mean, if Paul's not the driver, you don't really worry about the alcohol that was sold, then the connection with law enforcement sort of becomes irrelevant. So and it was clear what they were doing was they were trying to try a case that look at all the bad things, don't let him get away with this because of verdict against Parker's. And so I was interested in if we went to Beaufort, because I'm being told by Alec's lawyer, that a Hampton jury won't return a verdict against him. And so what I'm trying to determine is if we go to Beaufort, is the evidence that I have uncovered so overwhelming that a jury ignores the clear breaches by Parker's company?
And ultimately, again, without getting into the weeds, were the results of that exercise with the mock jury, did that give you further confidence in the strength of a large recovery against the defendant? Just answer
Yeah,
that.
absolutely.
And ultimately, did you communicate that to the defendant's defense team?
I did. I also, to Ronnie Crosby, who said that he would talk to Alec and then they wanted copies of some of the statements by the people that wanted to take everything he had.
What time period are we talking about right
This
now?
was May of 20.
Did you have anything else going on in your life as this time period was going as well?
Well, I was getting divorced.
Okay. That's significant.
Yeah. But yeah, so,
All right.
but yeah, I think you're later in the summer, but
I got you. As we move from May of 2020 into the fall of 2020, are those conversations continuing with the defense about the strength of your case and your desire to have a personal recovery against the defendant?
sure, there was a lot of pushback about the shock that I would hold Alec personally responsible, make him pay. And then in August of 20, I figured out that I had cancer, and but we continued to work. And then probably by November, I knew how bad it was, and I knew that I was going to be gone. And so I tried to make arrangements to do things because I'm still having to decide. The case is getting some age on it. We filed it pretty soon case that gets about a year old ought to go on the trial roster. We have mandatory mediation. We're going to mediate it in September, and then immediately after that, it would be eligible for trial. We didn't settle the case, and in November, I sent some requests to admit, which is in the law, in civil cases, there's all this evidence. It's like in here, you've seen this. You have to bring somebody in here that says, I opened the car door, and then you bring the next guy in and says, well, I took the mats out. And if that's not disputed, then we can send something, it's a written question, say, admit that it was daylight when this happened. Okay, we'll admit that. So we don't have to call somebody in. And so it's admit certain facts to be true, and then those things are taken as true, and we don't have to presume them. So I had made up my mind that I was going to send the case to Beaufort after the focus groups, and I was going to try the case in Beaufort. So I sent requests to admit in November of 19 before I was about to leave to go to Florida for my cancer treatment.
In November of 19?
I'm sorry, November of 20. I think it was November the 19th. But
All right, before we go there, you'd had some discussions with the defense about the strength of your case, as you've talked about, correct?
Oh, yeah.
And the strength of your case against the defendant, is that correct?
Yeah, and one of
Just
the
real
other.
quick, let me ask a question if you could.
Sure.
Had you had any discussions about a number that you were seeking from the defendant, roughly?
I ultimately, I have that conversation. They pushed me for a number. By November, I've given them a number, yes.
All right. And roughly what that number was?
That number, he was going to have to pay 10 million out of his pocket.
And did the defense have any response to you eventually?
That he could cobble together $1 million. But
Did
he
they
was
have any
broke.
other response?
He was broke.
He was broke. He can only get $1 million.
Maybe could get $1 million.
Based on your knowledge of the defendant and his practice as you've testified, did you accept that response that he was, quote, broke, end quote?
No, I didn't believe it at all.
Did you offer him any other sort of settlement, any sort of type of plan or anything like that?
If you're broke, I'm happy to work out a payment plan. You can make payments. You can convey Moselle. I knew he had Moselle. He got Moselle right after a big settlement in 2012. So that's 1,700 acres. Conveyed Moselle, convey the beach house. He still had the house in Hampton. And we'll work out a payment plan on the rest.
Did they reject that?
He did.
Having been told that the defendant is broke despite what you believe, did you have a response to them?
I did in October, almost immediately after the mediation, I served some discovery. Again, it's a written question, and there are two different types. There's interrogatories where you ask a question, tell me where you bank. And then there could be requests for production, give me your bank records. Now, I didn't say that, but I did. I sent discovery
And
to.
just real quick, we'll talk about discovery in a second, but generally, what is that response? He says, I'm broke. What are you saying in response?
There's no way. I mean, like I said, he has a spigot of money that's running. He's settling cases. He's got big cases. He's got lots of cases. He's got generational wealth. There's no way he's got 1,800 acres in Moselle. He's not broke by anybody's standards.
Did you ask the defense to, okay, show me the books, prove to me that you're broke?
I did.
And what was the response?
No.
So that led you to some discovery?
It led me to send discovery to get that information.
And specifically, what information as it relates to the defendant's books and the defendant's accounts are you talking about?
Well, it was broad, so it was broader than this, but what I was looking for was the institutions, the accounts where he did his banking. Because if he was in fact broke, if his bank account says zero or $5,000 or $7,000, it was because he was hiding it, in my opinion, at the time. So that's what I was looking for.
All right. And so you sent those discovery requests?
I did.
And did the defendant provide that information, or did they decline to provide that information?
They objected almost immediately.
And so did you then file some subsequent legal papers because they refused to provide the information about the defendant's accounts?
I did. I filed what's called a motion to compel, where I asked the judge to compel or make him give me the information.
I'm going to show you what's been marked as State's Exhibit 402. And just generally, just see if you recognize this document. If you flip through it real quick.
I do. It's the motion to compel that I filed with three exhibits, which are his lawyer's responses, the objections to the questions.
All right. What's the date on that document?
The
Motion to compel.
The motion to compel was filed October the 16th, 2020.
Your Honor, this time I would offer State's Exhibit 402 in evidence, I believe, subject only to a previous objection.
No additional objections, Your Honor.
It's admitted.
All right, can I have the screen over there, please? All right, this is State's 402, the one you just described, is that right?
That's right.
And that's the date on it right there?
Correct.
And I've turned over what's Exhibit B to this document. And is this some of that discovery asking for the defendant to identify his specific bank accounts that you were just describing?
That's right.
And can you just read number one right there? That's a question that you're asking the defendant to provide to you, correct?
Yeah. What you see there is the bold, the answer is, so this is, Alex's lawyer has retyped the questions that I sent. So that's the question that I wrote. Number one, list all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, and any other accounts over which you had signature authority for maybe in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present. And then the answer is what his lawyer said, which is generally an objection that's overbroad, it's unduly burdensome, it's not relevant, doesn't have anything to do with it. So
they had objected and you filed a motion to compel. And again, without too much detail, is a motion to compel to ask the judge in the civil case to force them to provide you this information.
that's right.
And if that had motion, and we'll talk more about this in a minute, but if a motion to compel is successful and you had gotten the defendant to produce the identity of all accounts he had, what would have been your next step if you continued to follow that thread?
Well, so I knew some information. I would have verified that he was telling me the truth, right? So some things I'm verifying, but I would have ultimately sent subpoenas to the banks. And then I would have begun to subpoena the accounts. I mean, I know he's got a personal account. I know that the law firm's got accounts, but he's got these other entities, these partnerships and things. I didn't know if he had accounts there. So that would have been what would have happened next.
At this point in time, were you aware of any institutions that you believe the defendant had bank accounts at?
I knew about Palmetto State Bank, and I believe that I knew about Bank of America.
At this point in time, though, did you have any idea about all the stuff over there with the fake forge account and all this other stuff that the jury's heard about?
Not a clue.
But had you been successful, you would have sought to identify all accounts in his name and then reviewed those accounts. Is that correct?
Yeah, the subpoena to Bank of America wouldn't have said, give me the information for account 102 or whatever the number was. It would have been for all accounts that have his name on it, period, in any capacity. So it would have been very broad.
And to be fair, they could continue to object to subpoenas and that sort of thing. But this was, if you had to follow this thread, that was the tack that you were taking by filing this document. Is that correct?
That's exactly what it was. And I was doing it. Like you heard Chris Wilson talk about in that Mack Truck case, that the defendant didn't want this to happen. Well, this is normal in a civil case. There's lots of times that defendants don't want certain things to happen. And so if they don't want it, that's what I want. And so I'm putting pressure where I can put pressure, and this is a place that I can put pressure. At the time, I think it's because he's making so much money, he doesn't really want us to know how much money he's making.
That motion's filed in October of 2020. Is there any hearing on that scheduled right away, or does that take sometimes a while for that kind of thing to happen?
It took a while. COVID wasn't over, but the courts weren't really running. There were some courts, when the Chief Justice began to open the court system back up, they had to have some kind of COVID plan in place. Hampton wasn't one of them. This case had been specially assigned to a judge from Lancaster. And so there weren't any real opportunities to get the motion heard at that time.
You had initially described how you were, initially, what county did you file this lawsuit in?
I first filed the lawsuit in its first draft in Beaufort County.
Okay. And as we're moving to this time period, COVID slowed things around. You filed your motion to compel. Are you considering moving that to a different county?
By November, I've pretty well made up my mind that I'm going to move it back to Beaufort County. And it's not just that I'm moving it back, it's that Parker's also had a motion, so I could consent to its motion to move the case back.
And so you're considering putting it in Beaufort at this point, is that right?
That's right.
And was that in part because the defense, or the defendant over there, believed that you couldn't get a verdict against him in Hampton County?
He was insistent.
As we move into early 2021, again, I don't want to get in for purposes of this trial for the specific discussion as it relates to other defendants, but had you started to reassess the decision to maybe take it to Beaufort County?
Yes. While I was in Florida, beginning in January, Mr. Parker, who owned Parker's Convenience Store, began to do a number of things that I thought would weigh against me going to Beaufort County.
And so did you communicate perhaps moving it or keeping it in Hampton County or moving it to Hampton County?
Not until I got back from my treatment in mid-April.
All right. Stand by for me real quick. Let me ask you this. You said you'd started considering moving it back to Hampton County because of some things that was happening with another defendant, that being the convenience store in Beaufort County, correct?
You said Hampton. I think you meant Beaufort.
Sorry, let me rephrase that. You're in Beaufort at this point, correct?
No, I'm in Hampton. I filed it initially against Luther's, which was a bar after. So the kids launched a boat from Alex family place to Chess, and it's owned by Family Trust, Murdaugh Family Trust. Maybe there are two properties and there's two trusts. So I sued Alex's father. I sued the trust because could have been that alcohol was provided there. It turned out it wasn't. But the kids drank and launched the boat from there. And then they went to an oyster roast. I sued the people who had the oyster roast. From there, they went to a bar called Luther's where Paul had 2 shots. And so I sued Luther's and I sued Alec. And I'm not 100% certain in that first lawsuit whether I sued Buster or not. But I ultimately did sue Buster.
You were describing you were in April 2021. Had you at that point had some thought process that you communicated to the defense about having the case in Hampton?
Yes, I did.
Okay. And was it because of some of those things with that other defendant that you had mentioned?
So it
Without
was.
getting into the
It was. And the motions were coming up. I mean, it was, I've been gone for 4 months or whatever it is, 4.5 months. And so the motions are set to be heard. And there are a number of motions. Parker, as I said, had filed this motion to transfer the case to Beaufort before I left.
As you're thinking about, as we're in April of 2021 and you're thinking about putting it in Hampton, you were still concerned though about a case against the defendant in Hampton County, his home county, correct?
I think you're still getting Beaufort and Hampton mixed up, but so not exactly. I was.
All right, well, you explain.
Okay,
to me.
I'll explain. There were a number of reasons that I wanted the case in Beaufort. I had substantial evidence. One of the things that we didn't talk about was when you have a 17, 18, 19-year-old girl, which I have, she constantly has her phone and she's constantly taking videos. And so one of the things that I discovered is that Paul's girlfriend had tons of videos of alcohol, family trips, videos of Paul drinking in front of his parents, videos of him grossly intoxicated. And so that evidence I shared with Alec's lawyers as well leading up to it. I didn't share it. They didn't serve the same discovery on me because they didn't want the other defendant, Greg Parker's, to have it at that time because they were so entrenched in that there was some sort of venue-friendly lawsuit going on between Alec and myself, but there wasn't.
As you're considering all these issues, did you ever convey to the defense any issue about suing any other defendants in Beaufort County if you felt like your case was not getting a fair shake in Hampton County?
So once I made the decision.
Ladies and gentlemen, we're going to stop for the day. We're going to resume at 9:30 tomorrow morning. Please not discuss the case. The nature of the objection.
Your Honor, as I understand this, the relevance of this under the state's theory is financial pressure due to the, he said, $10 million that he expected the defendant to pay. These details about interactions with other defendants, the relevance is just not apparent. And then there's giving.
Your Honor, through my questions, I've been trying to minimize getting into the weeds on that. I believe the response that the witness, I'm happy to proffer an answer to that particular question, is communicating to the defense that he, intended to sue Maggie and Paul in Beaufort County if he detected anything that he thought in Hampton County that was untoward. And I think that that's specifically relevant to the specific pressures that were rising on this defendant in April of 2021.
Well, I think you could have asked him that question, but I agree with the defense. You said you're not trying to get in the weeds, but you're far into the weeds into the other case, and I sustain the objection. And we will resume at 9:30. Mr. Harpootlian.
Your Honor. At some point in this case, the defense will have the opportunity to call witnesses. I'm not sure when that's going to be. Anyway, a number of our witnesses, when I say a number, at least 4, perhaps 5, are from out of state. They're experts. So it's prohibitively expensive for us to just fly them in and have them sit somewhere for a week or two. I wonder if we could inquire of the state, is there some end to their case that they predict will happen within, and because, Your Honor, if they tell us they're going to end on, I mean, it's sort of the reverse, they tell us they're going to end on 10 days from today, and they end 8 days from today, or we won't have witnesses to put up. So we delay the court. So, and it's not, I've talked to the Attorney General several times, and he has been unable to predict to me when that might happen. I thought perhaps, and I'm not asking he do that right now, but perhaps he could, Your Honor, would ask him, he could like consult with his team and think about when that might happen. And again, I'm only asking so that we don't say, we don't have a witness here. They're in Chicago or Connecticut or what, because they have to book flights and they have to, whining, I'm just saying, to some specific.
Reasonable request. I certainly understand.
I don't do that much. Thank you.
I believe, and I think the defense counsel will have to concede, I've been very accommodating at what our next day's schedule is and trying to provide that. I've tried my best to communicate with the defense, and I think he would have to concede.
Yeah, but he's not worried about that part. He wants to know, when are you going to be through?
Well, I think.
And I'm not
I told, he says I didn't tell him, and I told him that, right now I'm thinking at the latest midweek next week is what I was thinking. I told him that earlier today. And again, Your Honor understands these are fluid. Objection can happen, cross-examination happens, and camera proceedings can happen, but that is what I told him.
Does that give you a sufficient idea?
But if as this process goes on, they decide they need to, I mean, again, I said I accused him of gilding the lily and plowing on. It's apparently instinctive. I'm not criticizing it. It's his case. I am criticizing it. It's his case. But I just, and he has every day when I've asked him, who you calling tomorrow? Been 100% cooperative, and we're going to do the same for him. But as we proceed through tomorrow, and he thinks he's going to be done midweek, next Wednesday of next week.
That's my best assessment right now, yes, sir.
Okay, so what we're going to do is we're going to try to structure a plan where we have available witnesses Wednesday, Thursday, that we don't have to fly in, but it may be the following week before we can get those folks here, if that makes some sense. I mean,
I understand. Well, we'll need to address it as we go, and I think maybe reassess things and give you some lead time.
I'm in no way criticizing Mr. Waters. I want to say that. I understand it's a fluid situation. I've been where he is. I spent 12 years as a prosecutor. I know how difficult it is to project these things. Having said that, we've been here a little bit longer than I thought we were going to be. We projected a 3-week trial. We're now 3 weeks, or tomorrow will be 3 weeks. And our case is going to take, we think, at least a week. So if you've rented or set aside hotel rooms for a 3 or 4 week trial, it's probably best to make provisions. And we're going to try to pare that back. We think the jury may not remember what they heard 3 weeks ago the further we go on.
Okay, we'll just revisit the issue perhaps on a daily basis and see how we're going.
Thank you.
Thank you, Judge.
All right.